Hello, I'm back. Yay! I missed y'all. I have missed y'all. What is up? Happy hump day. Happy hump day. Are we gonna hump? Just kidding. Pause. What's up? What's up? What's up? We're gonna talk about the Menendez brothers. Hi, welcome everyone. It's been nice. It's nice to see you guys. It's been nice to be gone, but it's nice to see you guys. Let me see who I'm taking roll for. Debbie, Four-Wheelin', Tipsy, New Age Plug, what's up? Amber, Laura, Killiswag, Razon. Hey, 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 hey. I know I've been gone, but I'm back. Been working. Anyways, we're going to be talking about the Menendez brothers. You know me, the document. So I got the document. It's pretty long. We might just have to read half of it tonight. And then I want to watch the presser too. I have not been caught up on that. So Menendez brothers' petition to resentencing was denied by the DA. And it's a pretty intense document. So we should just get started. Thank you for being here, by the way. Oh, hey, Rach. Good to see you. Yeah, no. To answer your question, no. Okay, let's get started. Filed this February 21st. Erik Menendez and Joseph Lyle Menendez. It's pretty intense. It's good to see you guys. Hopefully we can catch up on Amelia After Dark later. Let's see. And let me know what you think about the Menendez brothers. Innocent? Should they? Well, they're not innocent, but you think that they should get another opportunity, right? Considering the abuse claims and everything going on. We're going to hear all about it in the document. So people, state of California, interest, Nathan J. Hochman, I don't know. District Attorney for Los Angeles submits this informal response to the petition of habeas corpus for Erik Menendez and Lyle Menendez. And the introduction starts with a quote from the trial. It says, "We have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will." Leslie Abramson, trial for Erik Menendez, August 18th, 1993. To resolve this case, jurors had to decide a single critical question: was Jose Menendez molesting his sons? That was Mark Garrados on May 2023. Counsel for the Menendez brothers. Let's get started. Contrary to Leslie Abrahamson's statement at the time of their 1990s trial, they would never argue that sexual abuse justified the killing of their parents. Erik and Lyle's current counsel in their 2023 petition has argued just that, namely, the only issue at trial was sexual abuse, not self-defense. While sexual abuse is abhorrent and may be a motive for murder, Abramson understood correctly that it does not constitute self-defense and justify murder unless the murderer has an actual fear of imminent harm. The jury was not asked to decide if the Menendez brothers were abused by their father and their mother failed to stop it. Only if the Menendez brothers committed these unalivings willfully, deliberately, with premeditation, or in self-defense. The quote-unquote new evidence submitted by petitioners, an updated copy of a letter from Erik Menendez to his cousin Andy Cano, and a declaration from Roy Rosello provides no additional evidence at all concerning this key issue at trial about self-defense and petitioner's mental state the night of August 20th, 1989, when they executed and shotgunned their parents over 12 times to their deaths. At most, and only supplements the voluminous evidence of alleged abuse the defense presented at the second trial, including 7 days of detailed graphic abuse, testimony by Erik Menendez, and testimony by Andy Cano. 12 times? That's a little excessive, right? That's overkill. We know that for sure in true crime. What year was this again? The night of the crime. So that was August, I just passed it, August 20th, 1989. Hey, 𝗟𝗶𝗸𝗲, good to see you. Petitioner claims in the habeas petition are not new. These claims have not been repeatedly raised and rejected by every court that has heard him, including the trial judge, the California Court of Appeals on direct appeal, the California Supreme Court, and the U.S. District Judge and Ninth Circuit Court of Appeals on a federal habeas petition. Similarly, these claims should be rejected again because neither the proffered trial evidence nor any new evidence they have proffered as a part of their current habeas claims alters the finding that the petitioners lacked an actual fear of imminent harm when they unalived their parents. In rejecting similar iterations of the claims in petitioner's federal habeas litigation, the Ninth Circuit Court of Appeals explained, with the other excluded evidence, the proffered evidence would have served only to explain why Lyle and Erik might have actually feared their parents. Even when viewed most favorably, the petitioners, the new evidence proffered in the instant petition merely bolsters why petitioners allegedly feared their parents, while the remaining evidence continues to demonstrate that petitioners planned a preemptive strike, purposely killing their parents before they believed they were in imminent danger. This is crazy. The DA is basically not for it at all. On March 20th, 1996, a second jury convicted the petitioners of the following crimes. Count 1, first-degree unaliving of Jose Menendez with special circumstance of lying in wait. Count 2, first-degree murder of Kitty Menendez with a special circumstance of lying in wait. Count 3, conspiracy to commit these crimes. As to counts 1 and 2, the jury found the true special circumstance of multiple murders. On April 19th, 1996, the trial sentenced each petitioner as follows. Count 1, life in prison without the possibility of parole. Count 2, life in prison without the possibility of parole. And count 3, sentence stayed pursuant to Penal Code Section 654. On May 3rd, 2023, petitioners filed the instant petition seeking habeas relief through new evidence pursuant to then Section 1473. They proffer only 2 items of alleged new evidence. This evidence is an updated photocopy of a letter without a postmarked envelope purportedly written by Erik Menendez to Andy Cano. The petitioner alleged corroborates the now deceased Andy Cano's trial testimony and petitioner's allegations of abuse asserted at trial. A purported declaration of Roy Rosello asserting that Jose Menendez molested him in the 1980s, which petitioners concede they did not know about at the time of their murder of their parents in 1989, found out about over 30 years later, but alleged encounters the trial descriptions of Jose Menendez as having been non-abusive. On June 15th, 2023, this honorable court requested the respondent file an informal response to the claims alleged in the petition. Petitioners' claims misstate the law and issues in their underlying case and do not make a prima facie case for habeas relief. Additionally, their new evidence regarding the Cano letter is procedurally barred for untimeliness. As such, the court should summarily deny the petition. Without question, this petition is designed to inflame public passion, mislead the court through underlying straw man fallacy that the sole issue in petitioner's second trial was whether their parents had abused them. The argument misstates the law and issues in the case. Factually, the defense in the second trial did present that Jose repeatedly abused his son and that Kitty had quiesced for most of their lives. Erik testified that Jose threatened to unalive him if he revealed the abuse. According to Erik, there had been several confrontations between Jose, Lyle, and Erik days before the crime. Erik testified at extraordinary length and in incredible detail about his childhood and his relationships with his parents, beginning with his allegations that the father began molesting him at the age of 6 and following through incident by incident until he was 18. Erik testified that in the days leading up to the unalivings, he had some fear that at some point his parents would unalive him, a fear that fluctuated in intensity during those final days. This is intense. They've been in here long enough. They will not commit another crime. Free them, says Laura. Hey, number 7, good to see you. And shout out to all my mods for being here. Appreciate you. Yeah, I have so many opinions about this. The 3 questions before their convicting jury were, did Erik and Lyle conspire to unalive their parents? Did they unalive their parents? And what were their respective states of mind when they collectively shot their parents over 12 times with shotguns? unaliving them. There was not a fourth question of whether Erik and Lyle were abused. The petition reasserts allegation that petitioners repeatedly and respectively asserted during their second trial, on direct appeal and in prior habeas petitions, which every court to consider them has repeatedly and respectively rejected. In particular, the petition reasserts that in the second trial, witnesses were improperly excluded, prosecutors made an improper closing argument, petitioners were limited in presenting abuse evidence, and the exclusion of imperfect self-defense and heat of passion instructions was erroneous. The recycled allegations and reassertions of their perennially unsubstantiated argument that they executed their parents to defend themselves from imminent peril. Petitioners craft a foundation for their current claims, hoping to show that their proffered new evidence justifies habeas relief. It does not. The law requires petitioners to establish the following for habeas relief on a claim of new evidence. New evidence exists that is presented without substantial delay, is admissible, and is sufficiently material and credible that it is more likely than not would have changed the outcome of the case. For purposes of the section, new evidence means evidence that has not been previously presented and heard at trial and has not been discovered after trial. Indeed, their new evidence does not substantiate their time-worn straw man fallacy that the central issue in their second trial was their parents had sexually molested them. More importantly, their new evidence does not establish that petitioners believed they were in imminent peril when they unalived their parents. For instance, the Rosello information could not influence petitioners in any way in August 1989, since they admit they only learned about this information over 30 years after the crime. As for the Cano letter, at most it illustrates that petitioners feared that their parents had the capacity to and might at some point harm them. It does not show that petitioners feared they were in imminent peril at the moment they shotgunned their parents to death. The fears leading up to the murders and the reasons why such fears might have existed simply are not the threshold issue for California's imperfect self-defense structure. This new evidence does nothing to show that at the moment of the killings, they had an actual fear and need to defend against imminent peril to life or great bodily injury to warrant the giving of the imperfect self-instruction. Therefore, petitioners do not make a prime facie showing that their new evidence would have more likely than not changed the outcome of their case, as they are statutorily required to do. In addition to not addressing the central issue of self-defense at trial, the new evidence claims fail for many other substantive reasons. Starting with the Cano letter, the new evidence, the undated, photocopied Cano letter does not meet the legal test for new evidence set forth in section 1473 subdivision. At least as it pertains to Erik Menendez, the Cano letter is not new evidence that was discovered after trial, as the statute requires. Instead, its purported author, Erik Menendez, could have easily introduced the purported December 1988 Cano letters during his 7 days of trial testimony in the second trial about the sex, physical, and mental abuse inflicted on him by his father, particularly during his extensive direct and cross-examination about when and how many times he disclosed the alleged abuse to Andy Cano. He did not. Or the Cano letter could have been introduced during the testimony of Andy Cano in the second trial to corroborate Cano's allegation that Erik Menendez had informed him about the abuse, not just 6 years before the murders, but within a year of the murders. Again, like with Erik Menendez's testimony, there was no mention of the Cano letter during Cano's trial testimony. Second, as to Lyle Menendez, the introduction of the letter, an out-of-court statement allegedly made by his brother to their cousin, for its truth would have been inadmissibly hearsay without showing a viable legal exception. I'm curious, do you guys think that that's true? Hello, D. Good to see you. It's been a while. Thank you for being here. I appreciate that. Smog Dog, what's up? This is very important, Melanie, just knowing. Yes, we're reading the documents. We all hate chumos very much. I have to still watch that documentary, Laura. I'm not like big on watching like stuff like that. I do think they should get another trial, though. I do believe that, at least. Whether they should be free, I don't know. Third, the undated photocopied Cano letters not new evidence because it is not credible in contravention to the statutory requirement. At trial, as noted above, neither Erik Menendez nor Andy Cano mentioned the Cano letter when examined and cross-examined in detail about how many times Erik Menendez had disclosed the abuse to Andy. In fact, The letter contradicts the testimonies of Erik Menendez and Andy at both trials, where they both said the last time they discussed the abuse was at least 6 years prior to the murders. It is inconceivable and defies common sense to believe that if the letter were actually written by Erik Menendez and received by Andy by approximately December 1988, within 9 months of the August 20th, 1989 unalivings, the defense would not have introduced the actual letter or its content during the trials. This evidence would have corroborated Erik Menendez and Andy's testimony about the alleged abuse that the otherwise was only supposedly discussed by Erik Menendez and Andy Cano 6 years before the crime, prior to Erik Menendez moving to California. The fact the defense did not introduce the letter or its content at either trial belies its purported existence prior to the unalivings and drastically denigrates its credibility. Moreover, the lack of credibility of the letter is in full alignment with petitioner's documented history of deceit, lies, fabricating evidence, and suborning perjury in this case. That history started before the crime, occurred in hours, days, weeks, and months after the crime, during the investigation, and continued on unabatedly before and during the years of the two trials. The deceit, lies, and fabricating evidence and suborning perjury evolved over the course of at least 5 different versions of events that Erik and Lyle told. 1. Erik and Lyle did not unalive their parents. It was a mafia hit. 2. The father was a violent predator who raped Lyle's girlfriend. 3. Their father abused Erik and their mother abused Lyle, without any mention of Lyle being abused by his father. Erik and Lyle were both abused by their father. Both their father and mother were going to unalive them the night of August 20th, 1989, which is why they shot them first. This is wild. They're basically saying that they're lying, right? All of it, like, tell the truth. This new DA wants them to admit they did it and done, and he will consider a retrial sentencing. This is wild. Hey, Knight, good to see you. So examples include days before unaliving their parents, Erik and Lyle conspired and planned to unalive their parents, among other things, driving over 120 miles to San Diego to purchase the firearms and ammunition using a false identification and address. Hours before they unalived their parents, Erik and Lyle set up a pre-planned alibi where they would pretend to have been at the Batman movie and then meet their friend afterwards at the Taste of LA event. During the crime, Erik and Lyle staged the brutal crime to look like a mafia gangland hit, shotgunning their parents over 12 times, including shooting their father in the back of his head and through his kneecaps after he was dead, and shooting their mother at point-blank range in her face while she lay alive and bleeding on the ground. Right after the crime, Erik and Lyle intentionally hid their crimes from the police by picking up all the shotgun shells and disposing of them, the shotguns and the bloody clothing. Okay, I'm shook because is that premeditation? Like, I think so. No? And then they like hid the clothes and stuff. What do you guys think? Right after the unaliving, Erik and Lyle tried to pre-plan. Oh, wait, did I just read that? Pre-planned alibi by trying to buy a movie ticket for Batman movie and calling to meet their friend. After the crime, Erik and Lyle called 911 and met the police outside their home, convincingly lying to them that they had come home and found their parents unalived. I didn't know that. I don't know. I feel like that's premeditated and they were trying to hide something. Why would they say it was a mafia hit? Anyways, in the months following the crime, Erik and Lyle convincingly and repeatedly lied to police, their family, friends, and the media, saying that the mafia had unalived their parents. After being arrested and awaiting trial, Erik and Lyle developed their next lie to that their father was a predator, violent predator. Lyle attempted to suborn perjury by offering to pay his girlfriend, 𝗵𝗵𝗃𝗃, to falsely testify that his father had raped her after throwing her onto the bed and ripping off her clothes. She refused to perjure herself. Awaiting trial, Lyle developed the next lie, telling people that his father had abused Erik and his mother had abused him. Lyle never said that he was abused by his father. Lyle suborned perjury by his girlfriend, 𝗟𝗶𝗸𝗲, by sending her a script to falsely testify that Lyle's mother had tried to poison the whole family in her presence. Baker testified falsely at the first trial and did not testify at the second trial. Lyle attempted to suborn perjury from Erik's friend, Brian Eslamenia, asking him to falsely testify that Erik and Lyle were so fearful of their parents. The week of the crime, they tried to borrow a handgun from Eslamenia for protection. Eslamenia refused to perjure himself. During that trial, Erik and Lyle lied when they said they went to Big Five sporting goods store in Santa Monica to buy handguns to defend themselves. The Big Five store in Santa Monica had not sold firearms for years at that point. There's a lot that they're being called out for on like lying and stuff, right? I don't put that people in this industry are monstrous. I don't ignore that. I believe that a lot of those claims are true, right? And we hear it from the Menudo bandmate too, right? How he says that he was abused by their father as well. So, hey Jules, hey Kat, good to see you guys. Yeah, but it all does seem premeditated. But again, you know, we don't know what happened. They could have been living crazy lives, rich, wealthy lives, and their parents was a big person in the music industry, right? Whose birthday is it? Who did I miss? Whose birthday is it? I'm sorry about that, and it makes me think my science teacher. Oh, happy birthday, Small Dog. Happy birthday. Okay, let's move on. Fourth, contrary to the express requirement for Section 1473, petitioners substantially delayed presenting their new evidence. As its purported author, Erik Menendez knew about the letter at the time of both of his 1990s trial, yet substantially delayed introducing it as new evidence for almost 30 years after his conviction and long after Andy Cano passed away. Lyle Menendez also substantially delayed bringing this evidence to habeas corpus. According to the petition in 2015, the petitioner's aunt discovered the letter in the late Andy Cano's personal effects and gave it to production assistant of Barbara Walters, after which it became a subject in a nationally broadcast 2015 Barbara Walters special about the petitioner's case. Yet instead of bringing the new evidence on habeas corpus immediately after that discovery, Lyle Menendez delayed for 8 years until finally raising it in 2023. Accordingly, petitioner's new evidence claim about the letter is procedurally barred for untimeliness. Claims that are ultimately untimely will generally not be recognized on the habeas corpus, if not subject to an exception. Erik Menendez, the purported author of the letter, waits decades after his conviction to raise this new evidence habeas claim. At best, Lyle waited almost a decade after the letter was globally published in a 2015 television special about the unalivings. The United States Supreme Court has held that a mere 5-year delay is substantial under California law. Given petitioner's lack of legally viable explanation, justification, or exception to the respectively substantial delays in raising the new evidence claim, the Cano letter, this claim is procedurally barred for untimeliness. Even more ancillary than the Cano letters is the petitioner's new evidence claim centered on Roy Bozello's allegation in his 2023 declaration that Jose Menendez abused him in the 1980s. To begin with, the petitioners failed to allege how such evidence would be admissible at trial in accordance with Section 1473. They cannot reasonably argue that such evidence is relevant to their individual state of minds when they conspired to kill and kill their parents in August 1989, since they admit they only learned about this information over 30 years after the murders. Furthermore, while the abuse under any circumstance is abhorrent, the assertion that any individual abused another in the past is not a recognized defense to the crimes of conspiracy to commit unalivings in California, especially when the killers didn't even know about the allegation of prior abuse when they unalived their alleged abusers. As such, Rosello's allegations are inadmissible and not sufficiently material and credible that is more likely than not have changed the outcome of the case. contrary to the requirements. Therefore, petitioners have not made a prima facie showing that Rosella's declaration meets the statutory test for new evidence on habeas corpus. Because petitioners completely failed to make a prima facie case for habeas relief on neither piece of proffered new evidence, the court should summarily deny the petition without issuing an order to show cause or ordering an evidentiary hearing on the claims in this petition. Okay, I'm curious to know, do you guys believe, A, that the mother was involved and she knew? Was she like a Jen Soto? You know what I mean? And then 2, why did they wait so long? 3, why did they go to Barbara Walters and not the police and not include that in this, right? If they wanted to be out and free. I do question a lot of these things. I don't know. Something doesn't seem right here. Statement of facts. Respondent adopts and asserts a statement of facts regarding the trial evidence as detailed in the appellate court's unpublished opinion in petitioner's direct appeal. Prosecution case in chief. On the morning of August 18th, 1989, 2 days before the slayings, Mark Heffernan, Erik's tennis coach, gave Erik a 2-hour lesson at the Menendez residence. Mr. Heffernan did not notice anything unusual in Erik's demeanor. On August 18th, 1989, Erik and Lyle purchased 2 Mossberg firearms at a Big Five sporting goods store in San Diego for $200 each. Erik presented a California's driver license and the name of Donovan J. Goodrow. Erik gave a non-existent address in San Diego. Erik indicated that the address on the driver's license was incorrect since he had just moved. Erik signed the firearm transaction form and 2 entries on the federal firearm log using the name Donovan Goodrow. Perry Berman received a telephone call from Lyle during the afternoon of August 20th, 1989. They discussed getting together in the evening. Berman said he planned to go to the Taste of LA, a food festival at the Santa Monica Civic Auditorium. Lyle indicated that he and Erik were going to see the movie Batman in Century City, but after the movie was over at about 9 or 9:30 p.m., he would go to the food festival. Berman waited until about 10:20 p.m. for Lyle and Erik to show up. However, the brothers did not arrive, and Berman went home. At about that time, Berman was leaving the food festival. 𝗟𝗏𝗃𝗯, a neighbor of the Menendez family, heard a series of 10 to 12 popping sounds. There was a series of popping sounds and then a lapse and then another series. Krom's son picked up the phone to call 911, but was dissuaded from doing so because Krom thought the sounds were simply firecrackers. Berman received 2 calls from Lyle at about 11 p.m. In the first, Lyle explained that he had gotten lost on the way to Santa Monica, and the festival had closed by the time he arrived. Lyle suggested that Berman meet him and Erik at a restaurant in Beverly Hills. Berman was reluctant, but because Erik was very insistent, Berman agreed. The second call was just a few minutes later, and Lyle asked Berman to meet at the Menendez home instead of the restaurant. Berman demurred and agreed to wait to give Lyle and Erik time to go home and pick up Erik's fake identification. Neither Lyle nor Erik showed up at the restaurant. Berman, upset at the turn of events, left the restaurant and decided to drive to the residence so he could yell at Lyle and Erik. When he arrived, he saw numerous police cars outside and was told by the police that there was some trouble. Berman went home. A 911 dispatcher received an emergency call at 11:47 p.m. concerning a possible shooting at the residence. The call made by Lyle said, "Someone unalived my parents." Lyle indicated that he had not heard anything unusual. He had just come home and discovered his parents had been shot to death. Beverly Hills police officers responded to the 911 call. When the officers reached the front of the Menendez residence, Lyle and Erik ran out the front door of the house towards the officers, screaming. Leslie Zoller was the investigating officer. He recovered wadding spacers for shotgun shells and shotgun pellets. Zoller opined that a total of 13 to 15 blasts were fired in the den. No ammunition was found inside the residence. No weapons were found in the den. The only weapons found in the house were 2 unloaded .22 caliber rifles in the closet of the upstairs master bedroom. The brothers spoke to the police after the bodies of the parents had been removed from the den and again in September 1989. In both interviews, they said they were elsewhere at the time of the crime. After the initial interview, they returned to the residence and requested entry so they could remove their tennis rackets from the den. During their initial interview, Lyle indicated the possibility that the killings were business related. Jose and Kitty expired from multiple gunshot wounds. Jose suffered 4 blasts with buckshot ammunition. Kitty suffered 7 gunshot blasts with buckshot ammunition and 2 gunshot blasts with birdshot ammunition. The wounds to Jose's legs occurred after death. So Jose was already dead when his legs were shot. This is wild. Randolph Wright, an attorney in front of the family, talked to Erik and Lyle the day after the crime. Erik mentioned the possibility of a mafia murder and discussed the possibility of probating his father's will. Lyle told Wright that he thought his father might have changed his will and that changes might be in the family computer. Lyle told Wright that there was a family safe, and Lyle said he could get to the safe immediately. He did so and brought it back to Wright's residence. Erik spent 2 nights in the spare bedroom with the safe before it was opened. Lyle did not want anyone else present when the safe was opened except for his brother. After the safe was opened in privacy, Lyle informed the family and friends that the safe was empty. Later that day, other relatives found Jose's 1981 will under the terms Lyle and Erik were the sole remaining beneficiaries. This document is making it seem like, they did unalive their parents for the money, and it was like a whole setup. Like, why was the safe empty? This is crazy. At the same time, the 1981 will was found. Family members realized there were entries on the family computer, possibly relating to a new will. 3 files on the computer directory were Will, Erik, and Lyle. No one was able to retrieve the contents of the files. Howard Witkin, a computer expert, testified that he received an emergency call from Lyle regarding files on a home computer. Witkin found the files but no information. Lyle asked Witkin to erase the disk because he was selling the computer and wanted to make sure that information relating to family financial matters was not discovered. Lyle also told Glenn Stevens that he found a computer expert to erase whatever was on the disk. Richard Wntkowski was hired by Lyle within a few days of the crimes to provide security services. Wntkowski provided 24-hour around-the-clock protection while Lyle was on the East Coast. Lyle told Richard that either the Colombian cartel or the mafia was responsible for the crime. Lyle also told his girlfriend Jamie that the killings must have been mob-related. Lyle terminated Richard's services after about a week, saying a deal had been reached and his life was no longer in danger. Both brothers continued to perpetuate the mafia hoax. Lyle hired bodyguards to protect him during the fall 1989 semester at Princeton University. Erik told Bainan in late September or early October that the unalivings were business-related and involved a man named Noel Bloom. His father had a problem with Bloom after the purchase of a distribution company. At the time of his death, Jose was chairman of the board of 𝗟EITG Entertainment with an annual salary and benefit package of approximately over $1 million. His assets included the family home in Beverly Hills valued at between $3.5 million and $4 million with a net value of approximately $1.5 million, property in Calabasas with a value of approximately $1.35 and stock in 𝗟EITG Entertainment valued at $5 million. Erik and Lyle each received $3,226.70, that's a lot, in life insurance as proceeds as a result of their father's demise at age 45. Whoa. Following the murders, Erik and Lyle went on a shopping and spending sprees. Just 4 days after the killings, Lyle purchased 3 Rolex watches and 2 money clips, charging more than $15,000 on his father's American Express account. Erik and Lyle purchased automobiles, houses, businesses, clothing, and expensive tennis services. The automobiles included a Jeep Wrangler for Erik and a Porsche 911 Carrera Cabriolet for Lyle. Erik and Lyle made videotape statements to their therapist, Dr. Jerome Oziel, on December 11, 1989. On the tape, Erik and Lyle discussed their relationship with their parents and the reasons they unalived them. Basically, Erik and Lyle told Dr. Oziel that they hated their father and the murder of their mother was a mercy killing. The contents of the Oziel tape were corroborated by Erik's confession to his friend Craig Signorelli. In fact, shortly after the crime, Erik walked Signorelli through the den of the Menendez home, explaining where his mother and father had been located when he and Lyle shot them to death. 2 witnesses, Amir and Jamie, testified about efforts to fabricate evidence. as Lamina, a high school friend of Eric's from Beverly Hills High School, started visiting the brothers in jail. Lyle asked Lamina to give testimony favorable to the defense, specifically to testify falsely that the day before the murders, Lyle and Erik came to him and said they needed a firearm for protection from their parents. Lamina's testimony was corroborated by a letter Lamina received from Lyle dated July 7th, 1991. Hey, Robert, good to see you. Hey, Domestic Pinup, good to see you. I'm happy to see you here. Is that right, Melly? Is what right? This is a document from the New Day. Yeah. I don't know. I don't think they're going to get what they want. I don't think so. I'm glad you made it, Domestic Pinup. And hey, Sean B, good to see you. Good to see you. Thanks for being here. 𝗟𝗶𝗸𝗃 and the other witnesses who testified that Lyle had asked her to give false testimony was the other witness. In December 1990, Lyle asked her to testify that his father had done to her what had been done to a character in a movie called At Close Range. 𝗟𝗃 was familiar with this movie, having seen it with Lyle. In the movie, a man gives his son's girlfriend a sedative, then tells the girl to stop seeing his son. The girl refuses, and the father violently attacks the girl. Lyle said 𝗟𝗃 had to do it because the large sum of money was to be placed in her bank account. 𝗟𝗃 said if the money appeared in her account, she would tell the police. The prosecution introduced into evidence 9 pages police seized from Lyle's cell before the first trial. These pages contain references to safe house in foreign cities. The materials also contain references to international travel and visas for different countries. Dr. Roger McCarthy testified in an effort to reconstruct the crime scene. McCarthy concluded that 12 shots were fired. Kitty and Jose were seated when the first shot was fired. The second shot killed Jose. The first shots were aimed at the head, and the later shots were aimed at the knees. The defense case. The defendants presented evidence disputing the crime scene reconstruction, concluding that the crime scene was too complex to do an accurate reconstruction. The defendants also presented witnesses relating to various matters and incidents occurring before and after the killings, and expert testimony that Erik suffered from post-traumatic stress disorder. Erik testified on his own behalf. He maintained that he had been physically and sex abused by his father between the ages of 6 and 18. He loved his parents, but unalived them because they were going to unalive him after he had disclosed to Lyle that his father had been abusing him. Erik also feared his mother. She participated in her husband's abusive behavior by condoning it. Erik in his testimony placed great emphasis on the last few days of his parents' life in an effort to show he thought his parents were going to unalive him. On Sunday, August 13th, 1 week before the shootings, Jose discussed the courses Erik would be taking at UCLA in the fall. Jose told Erik that he would have to come home several nights a week and sleep over. Erik believed he would be required to continue to have sex with his father, and his hope of escaping the abuse was gone. This is so brutal. I'd like to hear the defense reason for a new trial. Obviously, this is bias from the DA. I agree, Laura. This could be bias, and they are just making a point, right? I do agree. I do think, in my opinion, that they were being abused. I do believe that. And that's terrible, right? It's terrible. Who knows what they were experiencing? On Tuesday, August 15th, Erik told Lyle about the abuse activity between him and his father over the last 12 years. Lyle told Erik he would talk to their father and the activity would cease. On Wednesday, August 16th, 4 days before the shootings, Lyle told his mother that he wanted to speak to his father when he returned home from a business trip the following day. On Thursday, August 17th, 3 days before the crimes, Jose returned home from his business trip. Erik stayed away from the family home until nearly midnight because he did not want to be present when Lyle talked to their father. When Erik returned home, his father confronted him, and as Erik ran from the house, he saw his mother. He had a conversation with his mother, and she informed him that she was aware of what had been going on. Lyle told Erik about his earlier conversation with his father. Lyle indicated that he had threatened to tell the police or relatives if the abuse did not stop. Erik told Lyle they would both die as a result of Lyle's threats to Jose. Erik, who feared for his life, concluded that he needed a firearm because he believed his father would unalive him if the information about the sex activity were revealed. The idea of running away was dismissed as impossible, even though Erik had traveled extensively in the United States and had false identification. On Friday, August 18th, 2 days before the killings, the brothers drove to San Diego and purchased 2 new firearms. After arriving home, the shotguns were left in the car. Erik acknowledged that he intended to use a shotgun if necessary to shoot his parents. On Saturday, August 19th, the day before the crime, the brothers stopped at a firing range so they could practice firing the shotguns, but were told they could not use shotguns at the firing range. They also purchased buckshot ammunition after talking with a sales clerk who told them birdshot ammunition was essentially useless for stopping a person. The brothers stayed away from the home in order to avoid going on a family shark fishing expedition planned for 3 p.m. that afternoon. Erik was afraid his parents had planned to unalive him and his brother during the trip. When they returned home late in the afternoon, the family went on the fishing trip. The trip lasted from 4 to 11:30 p.m. Erik and Lyle remained at the front of the boat because they were afraid of their parents. After the fishing trip, the family returned home. Erik slept in the house and Lyle slept in the rear guest house. After Erik retired to his room, Jose pounded on the door, but Erik did not open it. On Sunday, August 20th, the day of the crime, the brothers had agreed that Lyle was going to talk to their father to see if they could come to some resolution of the problem concerning the abuse. Erik talked to Lyle about noon in the guest house, and Lyle said he had not yet gone into the main house to talk to his father because he was scared. Lyle said he would talk to his father later that afternoon. Erik left the house about 1 p.m. Erik returned to the mansion about 9:30 p.m. and talked to Lyle in the guest house. The brothers decided to go out, but their parents forbade it. Jose told Erik to go upstairs to his room. Lyle told his father not to touch Erik, and his father said he would do as he wanted. Lyle asked his mother if she was going to let this happen, to which she responded, "You ruined this family." Jose and Kitty went into the den and closed the doors behind them. Lyle ran to the top of the stairs to where Erik was standing. Erik was in a panic and told Lyle he did not let his father into his bedroom. Even though Jose never expressly threatened him that day, Erik thought they were going to come and unalive him. Erik ran to his bedroom and thought about locking the doors behind him, but instead got his firearm out of the closet and ran outside to his car. He ejected the 2 worthless birdshot shells he had placed in the firearm while returning from San Diego on Friday and loaded the firearm with the buckshot ammunition he had purchased the previous day. Lyle arrived at the car and loaded his firearm. They entered the house together, each with a loaded firearm. Lyle and Erik, who believed their parents had firearms inside the den, burst through the closed doors to the den of the foyer. The lights in the den were off. The room was illuminated by the flickering television. According to Erik, his parents were both standing. He indicated on direct examination that he began firing only after his father began walking toward him and Lyle. However, on cross-examination, Erik indicated that he had no idea if Jose took a step in their direction. Erik said that as soon as he saw his parents, he immediately started firing. Erik heard the sound of Lyle's firearm. Lyle shot his father in the back of the head. The brothers ran out of ammunition and went out to the car and reloaded. Lyle returned to the den. Erik heard one more shot and saw Lyle leave the den. After the shootings, the brother picked up the shells because they believed their fingerprints might be on them. When the police did not arrive, Erik and Lyle decided to leave the house. They drove to a movie theater in an effort to purchase tickets for a movie in an effort to fabricate an alibi. They purchased tickets for the 10:30 p.m. showing of Batman, but had to throw away the tickets because they were time-stamped. On their way to meet Berman, they stopped at a car wash and dumped the incriminating evidence into the trash. Rather than meeting Berman, they returned home and discovered the dead bodies of their parents. The defense offered several witnesses to buttress the argument of the abuse. While staying with the Menendez in the summer of 1977, Lyle's cousin, Brian Anderson, often heard Jose beat Erik and Lyle with belts and saw bruises on them. When the boys were young, Jose would grab them by their hair and hold them underwater. Erik was often hit by his father for not doing well in sports. This is crazy. Yes. Sorry, I'm like reading the document, so I missed some of the chats. The boys were abused. Mine is an unpopular position, but I follow this trial way back when it happened. I truly don't believe these boys should ever be free. Yeah, differing opinions are welcome, and I have covered some of the old trial. I have a Menendez brothers playlist, so I'll add this video to the playlist. You guys can watch. Hey, homie, hang out. What's up? A number of witnesses provided circumstantial evidence corroborating the molestation. When Jose was alone in the bedroom with either Erik or Lyle, no one was permitted to walk down the hallway toward the room. When Erik was 12 or 13, he confided a secret to his younger cousin, Andy. Erik told Andy that his father had been touching him in a sexual manner. Erik made Andy promise to keep the matter a secret and to never reveal it to anyone. Dr. Wilson, a clinical psychologist who specialized in the area of post-traumatic stress disorder, interviewed Erik for over 30 hours. Dr. Wilson concluded that he suffered from the chronic post-traumatic stress disorder as well as from battered person's syndrome and depression. Dr. Wilson opined that Erik's symptoms of PTSD disorder were severe as they were because his father subjected him to the repeated episodes of molestation and repeated physical assaults or threats of assaults. Dr. Wilson also opined Erik did not believe he could change his environment because of learned helplessness. According to Dr. Wilson, Erik felt helpless because there was nothing he could do to change his environment. Dr. Wilson also opined that Erik was hypervigilant. Hypervigilance refers to an excessive scanning of the environment for cues of threats or harm where in fact none exist. Dr. Wilson's conclusion was that by the end of the night of August 20th, Erik was in a panic state in which he had no time or ability for reflective thought. Dr. Wilson also diagnosed Erik as suffering from depression, with symptoms currently in remission because of medication. Dr. Carrie English, a medical doctor with a specialization in pediatrics and a subspecialty in the area of child abuse and sex abuse, examined Erik in August of 1993. Dr. English found no physical evidence of sodomy. Dr. English also reviewed Erik's 1977 medical records, which indicated Erik had been examined for a hurt posterior pharynx, ulva, and soft palate. Dr. English explained that although the injury could have been caused by an erect being shoved against the back of the throat, thereby bruising the posterior pharynx, there was no indication in the medical records as to the cause of injury. Dr. English acknowledged that the injury was consistent with being caused by a toy, which could have been placed inside the mouth or falling on a popsicle stick. Oh my gosh. Trigger warning, I'm sorry. Hey, meow. Hi, meow. Cat Randall gifting. Thank you, Cat Randall. I appreciate you. I missed it. But yay, welcome new members. Karen, Ashley, Callie Dime. Yay, I love Callie Dime. Liz Rose, 187. Great new members. Welcome to Mellyverse. Thank you, Cat Randall. I appreciate you. Jules, you're fine. I've been missing some of the comments because I'm reading, but I'm still here paying attention. Rebuttal. Sometimes after the unaliving, Signorelli, Erik's best friend, received a tour of the den and was told by Erik what happened on the evening of August 20th. Signorelli gave a statement to the police on November 17th, 1989, when he related the substance of Erik's confession, although he was not entirely truthful in his comments to the police. Some of the things Signorelli mentioned in his interviews were not known to the public. Dr. Park Deitz, a forensic psychiatrist, revealed materials and interviewed Erik on 3 separate occasions. Dr. Deitz concluded Erik was suffering from a lifelong mental disorder, at least from early childhood, known as general anxiety disorder. This disorder did not affect the critical reasoning aspects of the brain. Dr. Deitz indicated that post-traumatic disorder did not impair brain functioning. Dr. Deitz did not diagnose Erik with battered person syndrome. He disputed psychologist Wilson's claim that Erik was hypervigilant immediately prior to the crimes. Dr. Deitz also contradicted Wilson's conclusion of learned helplessness. In sum, Dr. Deitz opined that at the time of the shootings, Erik did not suffer from any mental disorder that would have precluded him from exercising reflective thought. Dr. Williams Vicari, a forensic psychiatrist, treated Erik for approximately a year and 1/2. Dr. Vicari opined that general anxiety disorder can affect a person's mental state at the time of an event. A person suffering from this disorder, if in a state of panic, could suffer an impairment in his ability to engage in reflective thought. In addition, the symptoms of PTSD overlap with those of generalized anxiety disorder, and the latter disorder makes a person more prone to developing PTSD. Child abuse, including sex abuse, is more likely to cause PTSD than generalized anxiety disorder. Petitioner's convictions. On March 20th, 1996, a jury convicted petitioners of the following crimes: first degree unaliving of Jose Menendez with special circumstance of lying in wait. Also for count 2, first degree murder of Mary Louise Menendez with a special circumstance of lying in wait. And then the special circumstance of multiple unalivings. Count 3, conspiracy to commit unalivings. On April 19th, 1996, the trial court sentenced each petitioner to the following: count 1, life without the possibility of parole; count 2, life without the possibility of parole; and count 3 was stayed pursuant to 654. Petitioners appealed the verdict on numerous grounds. Significant to this petition, their claims on appeal included exclusion of imperfect self-defense instruction, exclusion of heat of passion instruction as to Kitty Menendez, exclusion of certain source evidence, and improper argument by the prosecutor. In upholding petitioners' convictions, the appellate court made the following findings regarding the aforementioned appellate claims germane to this petition. Petitioners were not entitled to the imperfect self-defense instruction. The California Court of Appeal upheld the trial court decision not to instruct the jury on imperfect self-defense. We find no error in the trial court refusing to instruct on imperfect self-defense. Immediately prior to the shooting, the petitioners left the area near the den where their parents went into the den and closed the doors behind them. They retrieved their firearms from the hiding places, ran out of the house, and met at Eric's car. Instead of driving away from the residence, they then loaded their firearms with buckshot ammunition, went back into the house, and returned to the den and shot and unalived their unarmed parents while they were in the den watching television. Erik also candidly testified that the danger he thought existed was in the future when they came out of the room, and he knew that his parents could not shoot him and his brother through the walls of their home. In other words, there was not a danger of imminent harm because Erik and Lyle's parents could not unalive him until they exited the den. Erik also testified that on the day of the crime, his father never said he was going to unalive him. The California Court of Appeal found the exclusion of the imperfect self-defense instruction was strongly supported as it pertained to Kitty Menendez, stating, "There is also another reason why the trial court would be justified in not giving the imperfect self-defense instruction as to Kitty. The testimony of several prosecution witnesses and Erik tend to show that Lyle fired the fatal shotgun blast into his mother's face and head, unaliving her after he and Erik had shot her, and Lyle left the house, went out to Erik's car, reloaded, and re-entered the residence, firing the fatal shots." The appellate court noted that in finding the petitioners guilty of conspiracy to commit unalivings and in finding true the 2 special circumstances, the jury had found that the killings were deliberate, premeditated, and effectuated by means of lying in wait. I don't know. I kind of believe that their parents would make those threats, especially if he was so big in the music industry and he didn't want like the backlash of that, right? And things were different back in the day when in regards to abuse. Gender anxiety disorder, I've been diagnosed with it. It's awful. I'll say you're late. Just kidding. Don't black. Oh, thank you, Homing. The true crime queen is back. All right in the world again. Yeah, I'm back. No, I'm just kidding. Petitioners were not entitled to the heat of passion instruction as to Kitty Menendez. The trial court only allowed the heat of passion instruction to be given for Erik Menendez as it pertained to the killing of Jose Menendez. The trial court did not allow the heat of passion instruction to be given for killing Kitty Menendez. Erik Menendez challenged this ruling. On direct appeal, the California Court of Appeal stated the evidence indicates the petitioners, after initially shooting their parents and realizing their mother was still alive, went out to Erik's car and reloaded Lyle's firearm and went back to the residence to complete the act of murder. The appellate court noted that any error in not giving the instruction was harmless in the view of the jury's rejection of finding voluntary manslaughter as to the killing of Jose Menendez and its finding of first degree over second degree murder as to Kitty Menendez. I think they should get a new trial. I do. Regardless of what we think, there's so much going on that I think that it should be played out in a courtroom. I do. I think they should get a new trial. And that would be so wild to see that trial, right? The California's Court of Appeal held that the trial court's exclusion of source witnesses was proper, stating, "The limitations of testimony did not hinder the petitioner's presentation of the defense to jury. In most cases, the proposed testimony would have just served to corroborate the other testimony presented to the jury." The appellate court noted, the trial court allowed numerous source witnesses to testify on behalf of the defendants. The source witnesses were also allowed to testify in detail about the relationship the petitioners had with their parents. This testimony included incidents of physical and mental abuse by Jose and Kitty. The source witnesses were allowed to testify about Jose disciplining the petitioners by sending them to their room and no one being allowed to go down the hallway near the bedroom when Jose was punishing the petitioners. The trial court stated the principal issue was the state of mind of the petitioners at the time of the crime and the relevance of prior incidents may have had on the petitioner's mental state at the time of the killings. The source witnesses were allowed to testify extensively concerning many areas in effort to determine the state of mind of the petitioners at the time of the killing. We found no abuse of discretion in the trial's court limitations or exclusion of some source witness testimony. Despite this clear ruling from the appellate court and the fact that the excluded source evidence did not involve purported sex abuse evidence, petitioners reassert this argument in the instant petition. And I do not knock the concept of their dad being a monster. I absolutely believe that. We see it all the time in true crime. Usually it's people in your family or that know you that are committing abuse crimes a lot of the time. It's just facts. The California Court of Appeal held that it was not prosecutorial misconduct nor improper for the prosecution to argue in closing arguments that there was no convincing evidence that sex abuse had occurred. Specifically, the California Court of Appeal noted, the prosecutor argued a great deal of evidence was presented concerning the allegations of abuse, and as I indicated, there's no evidence whatsoever that the abuse ever took place. The prosecutor was simply commenting on the state of evidence before the jury. This is permissible argument. The proper testimony of petitioners would not have established sex abuse. The appellate court added, here, the excluded evidence would not have established what petitioners wanted to show, that they had been sexually abused by their parents. On October 5th, 1998, Lyle Menendez filed a habeas corpus petition in the California Supreme Court. In this petition, he raised the following claims. 1, ineffective assistance of trial counsel for alleged failure to raise an objection. 2, unconstitutional requirement for the petitioner's testimony before he was permitted to admit allegedly relevant evidence. 3, ineffective assistance of trial counsel regarding the trial's requirement. Petitioner testified before the introduction of evidence of his mental state at the time of the crime. And 4, denial of the petitioner's right to testify. On March 31st, 1999, the California Supreme Court denied the petition. On April 30th, 1999, Erik Menendez filed a state habeas petition in Los Angeles Superior Court. The petition was also denied. On September 7th, 2005, the Ninth Circuit Court of Appeal denied petitioners' consolidated federal habeas petition in Menendez versus Terhune. In this consolidated petition, petitioners raised the following issues. 1, the trial court's admission of the tape-recorded therapy session between petitioners and Dr. 𝗟𝗟 as therapist. 2, the trial court's denial of imperfect self-defense instruction. 3, the trial court's exclusion of testimony and the right to due process. And 4, the trial court's exclusion of testimony and the Sixth Amendment right to present a defense. And 5, improper closing argument by the prosecution. Admission of the 𝗟𝗟 tapes. Like I said, I have a playlist on the Menendez brother, and we cover some of this in the first trial. I'm trying to be good, Asain. Admission of the 𝗟𝗟 tapes. After killing their parents, petitioners met with Dr. 𝗟𝗟 and one of the conversations was recorded. In that recording, Lyle Menendez stated there was no way I was going to make a decision to unalive my mother without Erik's consent. I didn't even want to influence him in that issue. I just let him sleep on it for a couple of days. At trial, the prosecution argued to the jury that the 𝗟𝗟 tapes proved petitioners' decision to unalive their parents were willful, premeditated, and deliberate, and that this statement demonstrated that the murder was willfully deliberate and premeditated. The prosecution argued, in that conversation with Dr. 𝗟𝗟, they make it very clear this was a crime that they premeditated and deliberated, and no abuse is mentioned, no fear of attack by their parents. On federal habeas, petitioners claim that the admission of the 𝗟𝗟 tapes violated their due process rights. The Ninth Circuit Court of Appeal disagreed, finding that the trial court did not violate the due process in admitting the statement because its purpose was therapeutic and it was not prohibited by attorney-client privilege or made as part of the petitioner's defense. After the trial court and the California Court of Appeal denied the claim, Petitioners on federal habeas reasserted their claim that the trial's court denial of the imperfect self-defense instruction violated California and federal law. The Ninth Circuit Court of Appeal Court also rejected this claim. The Ninth Circuit Court found petitioners could not establish imminence of their fear they had claimed. The fear, no matter how great, cannot be a prospective danger or even one that is in the near future. Rather, an imminent peril is one that, from appearances, must be instantly dealt with. The Ninth Circuit Court reiterated that trial's court reasoning in the California Court of Appeals affirmance of not instructing on improper self-defense, imperfect self-defense. The defense presented insufficient evidence under California law, a belief in imminent peril, because Erik and Lyle left the house after the confrontation, went to the car, retrieved their firearms, reloaded their firearms with better ammunition, re-entered the house, burst through the doors, and began shooting their unarmed parents. The court concluded that there was no substantial evidence of a belief of imminent peril. The court placed special emphasis on Erik's testimony that Erik knew the danger to be in the future. Furthermore, the California Court of Appeal concluded that even if the trial court erred in failing to give the instruction, the omission was harmless because the jury necessarily resolved the question posed by the proposed instruction adversely to petitioners. The state court carefully applied state laws, principles, and factually similar state cases and determined that no instruction was available to petitioners because they failed to provide a basis upon which the instruction could be given. Quite simply, that should be the final word on the subject. The Ninth Court of Appeal ruled that petitioners have failed to show that they had been in imminent peril, and the prior abuse at the hands of the parents did not change the lack of imminent peril. Why would they go shoot them and then go back to their car and then come back and shoot them? It was overkill, right? Petitioners allege that the trial court's exclusion of the source witnesses, whose testimony was to establish why petitioners feared their parents, was improper and violated their right due process. The Ninth Circuit Court disagreed, finding that the exclusion of the source witnesses was proper because petitioners have failed to lay a necessary foundation for the actual belief of imminent danger. The Ninth Circuit Court of Appeal recounted the trial's court ruling that before the source witnesses could testify about why petitioners had feared their parents, petitioners had to lay a foundation for such testimony, which could only be accomplished if petitioners testified about the actual belief of imminent danger. The Ninth Circuit Court of Appeal agreed with the trial court. Indeed, we too see no other competent way in which the foundation could have been laid. The Ninth Circuit Court of Appeal quoted the trial court's explanation of its ruling. The issue as I looked at it and look at it now is the state of mind of the defendants at the time of the crime as to whether there was an actual belief of imminent danger of death or great bodily injury and a need to act. Obviously, if the actual belief is not presented to the jury, then the experts would have nothing to corroborate. Since the relevance of the expert testimony is related to the state of the mind of the defendants at the time of the killing, the purpose experts' testimony that they had, the defendants fit a certain diagnosis, that they are, whatever the experts say, a battered person, they fit the diagnosis of PTSD disorder, that is only to corroborate the defendant's testimony as to their mental state at the time of the crime. It's really irrelevant and would be totally irrelevant to any trial that the defendants had been abused or that they fit a particular diagnosis of being abused. That's totally irrelevant unless it corroborates their testimony as to their mental state at the time of the crime. If it doesn't do that, then the fact that they happen to be abused or happen to fit a particular diagnosis is irrelevant. I kind of disagree with that. And as I look at it, the foundation of the testimony of the evidence is the defendant's own testimony of belief. The Ninth Circuit Court of Appeal, like the California Court of Appeal, found that the trial court had properly ruled, stating only the defendants could testify to whether they believed the peril was imminent. Erik took the stand, but Lyle chose not to testify. The Ninth Circuit Court of Appeal held that the requirement petitioners lay the proper foundation before their source witnesses could testify did not violate their due process rights. I wonder why Lyle didn't want to testify. On federal habeas, petitioners allege that the trial court's exclusion of testimonial evidence violated their due process rights under the 5th, 14th, and 6th Amendment because the excluded evidence would have explained why petitioners felt they had been in immediate danger on the night of the shooting. Specifically, petitioners challenged the court's exclusion as either cumulative or lacking foundation. Some evidence relating to specific instances of physical, psychological, and sex abuse. And 2, some expert testimony that the petitioners suffered from battered person syndrome. In rejecting this claim, the Ninth Circuit Court of Appeal noted that the petitioner's claim here is closely related to the previous 2 claims we have rejected. The Ninth Circuit Court of Appeal stated that California Court of Appeals' conclusion that the trial court did not abuse its discretion in excluding this evidence because the court had admitted extensive evidence of the history of the petitioner's abuse at the hands of their parents. The very length of the defense case, more than 2 full months, belies on assertion that the court arbitrarily limited defense evidence. In finding it was not error to exclude this evidence, the Ninth Circuit Court of Appeal wrote, Erik testified about the alleged abuse in great detail for roughly 7 full court days. In addition, Brian Anderson, a cousin of Lyle and Erik, testified about severe physical abuse that the petitioners suffered at the hands of Jose. Diane Vandermolen testified about physical and verbal abuse by both Jose and Kitty. Andy Cano, also a cousin, testified that Erik confided to him that Jose was molesting Erik. Cano testified also that Erik always had bruises on his body. Several witnesses testified that when Jose was alone with one of his sons in the bedroom, no one was allowed to go near the bedroom. Dr. 𝗏𝗃 testified that Erik suffered from anxiety disorder that could affect his mental state. In addition, Dr. Wilson testified that Erik suffered from battered person syndrome, depression, and PTSD disorder. Given all of this testimony directly suggesting various forms of abuse as to both Erik and Lyle, the trial court excluded some of the other proffered testimony as cumulative. This decision survives scrutiny under Crane. We need not analyze this claim in any great depth, for even we were to conclude that the state court erred in its determination that the evidence was cumulative, such error would be harmless. As with the other excluded evidence we have discussed above, the proffered evidence would have only served to explain why Lyle and Erik might have actually feared their parents, but without any basis for support and with the imperfect self-defense instruction unavailable, this evidence was irrelevant. Indeed, without the availability of imperfect self-defense, the proffered evidence would likely have served only to confuse and mislead the jury. I need to go back to see what you guys are saying. Getting when your kid affects the rest. I agree, Laura. Childhood abuse is detrimental and it really messes with your mental health and so many things in life. No one can show how scared they were. Sometimes you can be terrified and no one understands why, even if it was in their heads, they were still scared. Yeah, and I don't knock the abuse claims. I think that those are true. I do. I'm just reading. 30 years, enough is enough. So Homie Hangout says if they acknowledge their wrongdoing, that's the standard for everyone else. But it's like almost impossible, right? Like their parents are gone. Most of the people are like gone. I don't know how a new trial would go if we saw that actually. And proper closing arguments by the prosecution. Identical to the argument they now assert in the petition in support for their instant habeas claims on federal habeas, petitioners argue that the prosecution made an improper closing argument in commenting that Jose Menendez had been a loving father and there was no evidence of sex abuse. Lyle Menendez claimed that his due process had been denied because the prosecution had moved to exclude purported evidence regarding abuse allegations and mental health. Lyle Menendez additionally argued that the prosecutor improperly argued that Jose was a patient man and one who would not be abusing his sons. Lyle Menendez alleged that the defense had been prevented from presenting evidence to the contrary, that in fact, Jose Menendez was an abusive father who had mistreated his sons. The Ninth Circuit Court of Appeal rejected petitioner's claim, stating that the defense had been allowed to quote unquote present substantial evidence relating to the allegations of abuse. Indeed, Erik testified for 7 days about the various types of physical, mental, and sexual abuse he claimed that his father inflicted. The Ninth Circuit Court of Appeal noted Erik Menendez had admitted on cross-examination that despite the years of purported abuse, there was not a single witness who could testify that they had ever seen Jose hit his sons, and Erik Menendez could not produce a single witness who had ever asked him about any bruises or welts that he allegedly had received from Jose. I think that's so messed up. Like, just because they don't tell people that they're being abused doesn't mean that it didn't happen, right? The Ninth Circuit Court of Appeal highlighted the following expert of the prosecution's closing argument. I asked Erik Menendez, bearing in mind you were so frightened of your father, he was always going to punish you for everything. What was the punishment for the burglaries? And he said, no punishment. No punishment for the burglaries. Ladies and gentlemen, Jose Menendez was not a punitive man. Jose Menendez was a man who forgave his sons time and time again, even for the most serious transgressions. He was a very patient man, and as much he was disappointed in his sons, and he forgave them. Lyle Menendez admits, and I even questioned Erik Menendez about this while he was on the stand, and Erik Menendez doesn't deny the truthfulness of his assertion that Jose Menendez cried when he heard about the Calabasas burglary incident, and Jose Menendez cried when he heard about his son's failure in Princeton. He said, Lyle Menendez says, after the Calabasas issue, he cried and we were together. We were close. This was the first time he cried in front of me. And he later goes on to say, he cried after the Calabasas issue, after I said, you know, Erik and I were very sorry in the whole deal, and I'm sorry for all the trouble that you were caused through this whole issue. And he cried and he felt, I think he cried a lot after the Princeton issue, and I came to him and I said this and that. Again, they want you to see Jose Menendez as a cold monster. It's easy to make those claims, ladies and gentlemen. It's very easy, especially when you claim, quote unquote, well, Mr. Khan, this happened behind closed doors, you see. That's the reason why I don't have any witnesses, Mr. Khan. It all happened behind closed doors. But ladies and gentlemen, Jose Menendez was a man who wanted the best for his sons. Time was precious to him, yet he took time out of his own schedule to attend all of the sporting events of his sons, and he was a man who cried for his sons. That kind of pisses me off. How do you really know he wanted the best for his sons, right? I don't know. That makes me feel kind of sus. The Ninth Court Circuit of Appeal found the prosecutor's argument was proper and based on the evidence that the jury had heard that Jose Menendez was not abusive, contrary to some of what the witnesses had testified. Petitioners re-allege here what they unsuccessfully alleged in federal habeas, that the prosecutor's argument of no sex abuse was inappropriate because petitioners have prevented from presenting evidence of sex abuse to the jury. The Ninth Circuit Court of Appeal rejected this claim and found no inappropriate argument in this trial court. I've done work for crimes of child SA, and hardly ever can they get legitimate proof that it had happened to the extent of being able to go back years, over 20, 30 years on claims like that. So I'm not surprised, but I also don't think it's fair. Abusers do stuff like that to cover their tracks. They act like everything's okay to keep up appearances. Yeah, I agree. Thanks for being here, Smog Dog. Happy birthday. What did Domestic say? Didn't a member from the boy band Menudo say? Yes. Yeah. So it's not just them, That's why I do think it should be considered. I do feel for us. Okay, well, okay. And he was 10 years older. Oh, that's interesting. Thanks for being here, Smog Dog, on your birthday. I appreciate you. And hello, Irony. Good to see you. Petitioners' documented history of lying and fabricating evidence. In analyzing the current new evidence, habeas claims it is critical to consider petitioners' established history of lying and manufacturing evidence in the underlying case. Petitioners' fabrications and evidence fabrication started before the murders and continued through the trials. Before the murders. Days before killing their parents, petitioners purchased shotguns from a gun store over 2 hours away from the house and used a false identification and address when purchasing these firearms. Prior to unaliving their parents, petitioner visited a firearm store in Santa Monica. After visiting that firearm store, they drove over 2 hours to San Diego to buy 2 firearms. While purchasing the firearms, Erik Menendez lied by stating his name was Donovan Goodrow and by providing Goodrow's identification and a fake address, as Erik Menendez testified on direct examination in the second trial. Question: when you filled out the forms, did you see any particular name for this purchase? Answer: Donovan's name. Why did you sign Donovan Goodrow's name? And did you sign Donovan Goodrow's name? Yes. Did you use an address on this form? Yes. What address did you use? I don't remember the address. I know it was August Street. I had forgotten the address that I was supposed to remember, so I just, on the spur of the moment, used the name of the month that was August. Yeah, I kind of question why he would buy those firearms under a different name. After the crime. Immediately after killing their parents, petitioners engaged in a series of actions to dispose of evidence, fabricate alibi evidence, mislead investigators, and lie to their family and friends about the unaliving of their parents. First, after shooting their parents, petitioners picked up the shotgun shells in a blatant attempt to hide evidence connecting them to the killings. Erik Menendez testified on direct examination in the second trial. What did you do? We went into the den. I remember my brother went into the den to get his firearm, and I remember we were walking out of the foyer and one of us said to pick up the shells. Question, did you pick up the shells? Yes. Why? Just flashed. I remember it flashing through my mind. I don't know if it was after my brother had said it or if because of that I said it. There might be fingerprints on the shells because we had handled them. So we just decided to pick them up since there was no one coming to the house. Next, petitioners attempted to create an alibi, leaving their dead parents in the den. Petitioners left to buy movie tickets to create an alibi for the time of the crime. They wanted to purchase tickets for a movie of 8 p.m. before the murders, but arrived at the theater too late and had to buy tickets for a movie starting at 10 p.m., the next available time. Erik Menendez testified to the following in the second trial. Following the death of your parents, when you went to the movies, you actually purchased a ticket. Did you not? To get inside that would have allowed you to get inside the movie theater? Yes. And the ticket you received was timestamped for the 10 o'clock show. Is that correct? Yes. You wanted one for the 8 o'clock show, correct? We tried to get one. We couldn't get one. After purchasing the movie tickets, petitioners continued to deliberately hide and destroy evidence. They drove from the movie theater up Coldwater Canyon toward Mulholland Drive to hide their shotguns. During his direct examination in the second trial, Erik Menendez testified about the lengths he went to conceal the weapons. Question, you got out of the car? Yes. And you got the shotguns from the back? Right. Did you take the shotguns out of the back of your car? No. Why not? There were shells all over the car at this point, and I just grabbed the guns and I don't know why anymore. You said you had to go down a steep bank. It was a steep bank. I remember falling at one point and sliding down. At one point, I'd gotten so far, I just decided to stop and put the guns there and run back up. In what manner did you leave those shotguns? I had put them next to a bush and tried to brush something over them, but they were exposed. I remember seeing the lights way up at the time of the hill at the top. Once petitioners had hidden the shotguns, they went to a gas station to dispose of additional evidence. Erik Menendez testified to the following in the second trial. Why did you stop at a gas station? To get rid of everything in the car. And did you stop at a gas station? Yes. What did you do at the gas station? I remember there was a car wash at the gas station. We parked near the dumpsters and quickly got out of the car and tried to find everything that was in the car. It was dark. I remember seeing red spatter on my pants. I took them off. Blood spatters? Yes. Where were they? On my pants. After disposing of all the evidence they could, petitioners continued to fabricate an alibi. Specifically, petitioners tried to meet a friend, Barry Berman, and to be able to say they had been with him at the time of the crime. Petitioners attempted to schedule a meet with Mr. Berman before the murders, one of the overt acts alleged in the conspiracy to commit murder that the jury found true. While testifying in the second trial, Erik Menendez admitted on cross-examination. After you shot your parents to death, you decided to make contact with Barry Berman. Isn't that correct? Yes. What was the purpose of making contact with Barry Berman? To try to have some place where we could say we were when the police asked us. And you were going to spend the evening sitting down at a restaurant somewhere with Barry Berman. Is that correct? That was the idea. It's simply we weren't in any emotional condition to do that. At one point, you felt you were in an emotional condition to carry that off, didn't you? Yes. And because you felt that you were in an emotional condition to carry that off, you and Lyle agreed that that's what should happen. He should contact Barry Berman and try to get together with him. Is that correct? Lyle didn't discuss it with me. He went in to see if Perry was still at the Civic Center. He didn't find him, so he called Perry on his own, trying to get Perry to meet with us so we could at least say he met with Perry that night. And it was your understanding when you went in to meet with Barry Berman that you were going to sit down somewhere with Barry Berman and he was going to be your alibi witness. Is that correct? I don't know. We were going to sit down with him or just be there. I think they were stand-up tables where you walked around. I didn't go in, so I could only see through the fence. Certainly, we were going to try to meet up with Perry. Contrary to Erik Menendez's testimony, Mr. Berman testified that the plan to meet the petitioners would have made hours before the crime, corroborating petitioner's alibi preceding the murder. During the second trial, Mr. Berman testified the following conversation that happened on the day of the crime. Did you receive a call from the defendant, Lyle Menendez, after you spoke to his father? Yes. And about what time did you receive the call? I believe it was around 5 to 6 p.m. And at that time, did you have a conversation with the defendant? Yes. And what did you discuss? About getting together that evening. And I told him that I already had plans to go to the Taste of LA, which is a food festival down at Santa Monica Civic Auditorium. And he said he already had plans with his brother to go see Batman. And I believe it's Century City. Did he mention the defendant, Lyle Menendez? Was he the first one to suggest getting together? Yes. And after he told you that he had plans to see Batman and you had plans to go to the Taste of LA, what did you discuss doing, if anything? About possibly getting together later that evening. He was going to see the movie, and when it got around 9 to 9:30, he head down to the Taste of LA. So after 10:15 rolled around and you could not find either defendant, you went home. Did you hear from them? Yes. Did you hear from one or both? One. Which one did you hear from? Lyle. And what times were you called by the defendant, Lyle Menendez? 11:07 approximately and 11:15 p.m. Mr. Berman testified to the tone of Lyle Menendez's request to meet that night. He was very persistent and he wanted to see me that evening. In response, Mr. Berman agreed to meet petitioners at the Cheesecake Factory in 20 minutes. After receiving this call, Mr. Berman received a second call from Lyle Menendez asking Mr. Berman to meet petitioners at their home. Mr. Berman stated he would not do that. Let me check in with you guys. Have a good night, Kat. Thanks for being here. We're going to read a few more pages of this, and then we're going to watch a little bit of the presser. We'll have to finish this tomorrow because this is a really long document. Mr. Berman did not know at the time Lyle Menendez wanted him to come to the house so he could serve as a witness for the petitioners when they claimed to have discovered their parents' dead bodies. Erik Menendez testified in the second trial that this was Lyle Menendez's plan, stating on cross-examination. Question: are you saying that the plan to have Perry Byrne come to your house and be present when the bodies were discovered was a plan of Lyle Menendez and you had nothing to do with that plan? Answer: I don't know the conversation that Lyle had with Perry. I wasn't there. I know that he asked Perry to meet him at the house. At least I think that's what he asked him. Perry said, no, let's meet at the Cheesecake Factory. So Lyle said, okay, we'll be there. Question: so you're saying you had nothing to do with any plan that Lyle Menendez had to meet Perry Berman at your home. Is that correct? Right. In the few hours between them murdering their parents and making their crying and screaming 911 call, petitioners removed all shotgun shells from the crime scene, drove to a movie theater and purchased movie tickets, drove to Mulholland Drive and descended the side of a mountain to hide 2 shotguns they had used for the crime, drove to a gas station and discarded their bloody clothes and other evidence, drove to Santa Monica to meet Mr. Berman, and called Mr. Berman twice to try to meet him to create an alibi. When cross-examined about their pre-911 call actions, Erik Menendez testified. Question: well, weren't you trying to trick the police that evening and cause them to conclude that you had nothing to do with the killing? Certainly, by the time I did not want them to know. And to achieve that goal, you went through the considerable effort prior to calling the police to ensure that you would not be suspects. Is that correct? You mean trying to get tickets and get rid of the firearms and so on? Correct. Yes. And that it was all designed to fool the police into thinking you had nothing to do with the crime. Isn't that correct? At that point, we wanted them not to think we had anything to do with it. Yes. After the 911 call. After the discovery that Jose and Kitty Menendez had been unalived, petitioners continued lying to law enforcement, family, and friends. Erik Menendez testified the following on cross-examination in the second trial. Did you lie about your involvement in this incident, Mr. Menendez? Yes. And you lied from August the 20th of 1989 up until the time you were arrested. Is that correct? Whenever anyone brought up the death of my parents, I was not going to tell them that I was involved. Not only you wouldn't tell them that you were not involved, but not only wouldn't you tell them that you weren't involved, you told them you were not involved. Is that correct? Right. And you did that to avoid punishment and responsibility. Is that correct? Yes. But by Mr. Khan, and you not only lied on your own, but you also conspired with your brother Lyle to lie and deceive law enforcement authorities. Is that correct? You mean to tell the police that we had not done it? Yes. And your lies concerning this incident began before the 911 call. Is that correct? On the way driving home to call 911. That's when you and your brother began to conspire to deceive the police. Is that correct? Yes. And you worked out a series of lies that you were going to tell the police on the way home, correct? Yes. And you reached an agreement to tell those lies so that both you and your brother would be held responsible for the crime. Is that correct? Yes. And you pursued those lies with Sergeant Edmonds that day. Is that correct? Yes. And you understood that the Detective Edmonds was seeking information that would help them solve the crime. Is that correct? Yes. And you had no intention of providing them with any information that would help them do that. Is that correct? That's right. And he specifically asked, can you think of anything else that's going to help us? And you said, I can't help you. I don't know. Is that correct? Answer, right. And that was a lie when you said, I don't know, wasn't it? It was. And the lies continue when you spoke to Detective Zoller in September of 1989. Is that correct? Yes. In fact, you lied to the police at every chance, every opportunity you had, didn't you? When it concerned me being responsible for this, I did. So you told Detective Zoller a lot of lies on September 17th, didn't you? Yes. You lied to other people as well, didn't you? Most specifically, my family. Who did you lie to in your family? I didn't want to tell my family that I was responsible. I don't think they ever asked me, did you do this? What you told them was you came home and you found your parents in that condition. Is that correct? Right. And that was a lie? Yes. Who did you tell that to? I don't believe many people in my family asked about it, but whoever did, I would have told them that. You lied to everyone in your family to believe that you were not responsible. Is that correct? Right. And you lied to friends as well. Whoever asked me about that night. Were you interviewed by reporters? John Johnson, Ron Sobel, and you lied to them as well, didn't you? Yes. Did you lie to people in your father's business? Whoever asked me about that night, I would either say I don't want to talk about it or not tell them I was responsible. And you called Mark Heffernan that night because he was a close friend of yours. Is that correct? I don't know if he was a close friend, but he was a friend who was a good guy. And you lied to him too, didn't you? Yes. Lyle Menendez also testified during the first trial that he had lied to police, family, and friends in the media, testifying. Okay, now in addition to lying to the officers who came to the scene, you then went to the police department for an interview with Sergeant Edmonds. Do you remember that? Yes. And when you saw Sergeant Edmonds, you lied to him too, correct? Yes. Now, at the time that the police arrived at your parents' home, shortly thereafter, a family friend or a friend of yours and your brothers arrived, and that was Mark Heffernan, correct? Shortly after at the house, yes. And he had accompanied you to the police department. Is that correct? Or he went in a separate car? Right. And did you lie to him too? In that sense, we didn't tell him what had happened. Yes. So you, again, to him, portrayed yourself as having been a witness and not a suspect in the crime, correct? Right. All right. Now, who else did you lie to about this? Did you lie to your family about it for a long time? In addition then to lying to your family, you also lied to your father's business associates about your participation in the murder, correct? Right. And you were also interviewed by newspaper reporters, correct? I believe so. Lyle Menendez also lied to the media as he testified to on cross-examination in the first trial. Were there two reporters together when you interviewed them? Are you talking about two separate occasions? Oh, you're right, two separate occasions. And there was one interview, I believe, with two people. Do you remember telling one of those reporters the following, quote unquote, finding out who it is, Eric and I are probably not going to be able to do anything about it. To find out who it is and not be able to do anything is probably worse than not knowing. So it's a hard thing for Eric and I to go decide whether or not we would want it solved. Do you remember saying something to that effect to the reporters? I probably did. In the first trial, Lyle Menendez admitted the purpose of the interview was to say that he did not want the investigation to continue. After Lyle Menendez was arrested, he still dated Jamie. During his incarceration and before he even claimed to have been molested, he asked Jamie, among other things, if she would find criminal cases for him, particularly cases where defendants were exonerated for unaliving their parents. During the first trial, Ms. 𝗔𝗄 testified. And did you ever go to Santa Monica, any court proceeding that Lyle Menendez attended during the summer of 1990? Yes. And did you go to court to support him during that period of time? Yes, I did. What was the nature of the case? Well, let me ask you this. Did you ever read any of the cases that Lyle Menendez asked you to look up? Well, I read parts of them, yes. And did you get a feel for what kind of cases you were looking at? Yes. Could you describe the nature of the cases that you were asked to look up and Xeroxing for Lyle Menendez? The cases were situated where children had gotten off after killing their parents. Was there any other kind of cases, any other subject matter of a criminal nature that was involved in the cases you were asked to look up? Not that I recall. Anything about child molesting? I believe so, yes. I mean, the cases where, child molestation and, children had unalived their parents and had gotten off. This is crazy. Hi, Natasha. Hello, Holly. Good to see you. Sorry if I missed you guys earlier. I've been reading the document. We're reading the petition for the Menendez brothers. We're going to read half of it, and then we're going to watch the presser in a second. As detailed post, Mr. Cano did not disclose to anyone that Erik Menendez had told him he had been molested until 1991. Mr. Cano's disclosure posted Lyle Menendez research of cases involving people who had been acquitted for unaliving their parents after claiming the murders were the respective results of sex abuse. Months after Ms. 𝗶𝗍 provided him with the cases, Lyle Menendez disclosed the alleged molestation and confessed to the unalivings of his parents. During the first trial, Jamie testified the following. What did you ask him? I at the time wanted to know the truth. And what happened? At that time, Lyle held up a letter because he did not want to discuss this over the phone system that was there. So he held up a letter and it was just described that he and Erik had unalived their parents. Could you tell me essentially what the letter said that you read that Lyle Menendez held up for you that day? The letter just said that he was very sorry and that he had to lie to me for so long, but the truth was that he had unalived his parents, he and Erik, and that the reason was Erik had been abused by his father and Lyle had been abused by his mother. I'm shook. I'm shook if the mom had something to do with it. And was it at that point you stopped reading, or was it at a different point? That was when I stopped reading. And when you stopped reading, did you say anything to him? Yes. What did you say? I don't believe you. Attempt to fabricate that Jose Menendez had raped Jamie before claiming their parents had sex abused them. Lyle Menendez tried to fabricate evidence that Jose Menendez had attacked his girlfriend, Jamie 𝗶𝗍. This evidence was not presented to Erik Menendez's jury in the first trial. In the second trial, Ms. 𝗶𝗍 testified that she had visited Lyle Menendez in custody in 1990 and talked to him about his defense. In that conversation, Lyle Menendez told her that he wanted her to testify about his father. Answer. In this conversation, Lyle had asked me if I would say that his father had done what was done to a character in the movie, and the movie was called At Close Range. He asked me to lie and say that his father had done that to me. Now, were you familiar with the movie At Close Range? Yes, Lyle and I had seen it together. And when you said a scene, did he call your attention to this particular scene? Yes, he did. And you could describe the scene? The scene was one in that the father of the main character and the girlfriend of the main character were in a room together, and the father had given the girl a pill, a rug, and she was a little groggy. And the father had asked her not to see the sun anymore. And she said she couldn't do that because she loved this character, and then she proceeded to try and leave. And she had proceeded to try to leave, and the father character would not let her leave the room. And then what happened was the father kind of looked at her very strangely, and she said no. And then the father said, I'm not asking you. And then he pushed her down on the bed and proceeded to attack her. I've never seen this movie. I'm curious now. And when Lyle Menendez asked you to say that his father had done what the character in this movie had done in the scene, how did you respond? Well, it had been about a year, I guess maybe a little bit longer since I had seen the movie, but I knew exactly what Lyle was talking about. And I just basically said, I can't believe you're asking me to do this. And it's a lie, and nothing like this had ever happened. That your father would never do that to me, nor did he. And how did the defendant respond when you said that? He said that I had to go do it because a large sum of money was going to be placed in my bank account and that I had to do it. And I said, the minute a cent is put into my bank account, I'm going right to the police with this. An astonishing piece of evidence came to light after the first trial. The discovery of a letter Lyle Menendez had written to Amir Brian 𝗟 asking Mr. 𝗟 to fabricate evidence and conspire to commit perjury for petitioners. Mr. 𝗟 received the 𝗟 letter prior to the first trial on July 9, 1991, but did not testify until the second trial after the prosecution discovered the letter. Mr. 𝗟 had been Erik Menendez's classmate and had visited petitioners while they were in custody on the underlying case. Mr. 𝗟 also testified he had conversation with petitioners wherein they had discussed what they thought he could do to help them with the case. In the 𝗟 letter, Lyle Menendez concocted a story he wanted Mr. 𝗟 to testify to a trial to corroborate the telling of the same false story that Lyle Menendez would testify to when he took the stand. Lyle Menendez asked Mr. 𝗟 to testify that Mr. 𝗟 had given Erik Menendez a firearm prior to the killing of Kitty and Jose. Lyle Menendez offered to provide Mr. 𝗟 with an untraceable firearm to corroborate the story if he didn't have one himself. Additionally, Lyle Menendez told Mr. 𝗟 to falsely portray Jose Menendez by testifying to a made-up statement about a father unaliving his son, taken from a scene in the movie At Close Range. that Mr. Islamina would attribute to Jose Menendez. The Islamina letter also instructed Mr. Islamina to testify about other incidents involving petitioner's case. Specifically, that Erik Menendez had told him that Jose had taken them out of the will. Finally, the Islamina letter instructed Mr. Islamina on how to destroy the Islamina letter after reading it. I'm shook. I am out of touch with this case. Well, Holly, I'm glad you're here. Yeah. I have a playlist on it. There's a lot of information on this case, but that movie does sound crazy. I don't know. I'm shook. I'm just shook. I definitely think they deserve a second trial, though. Well, it would be a third now, I guess. I'm going to play the presser for a minute. I have not watched this. I am shooketh.
Has been on 3 parallel tracks. The first track was the habeas track.
Resentencing, but they should get a new trial, I think.
Motion filed in May of 2023, where the Menendez brothers are asking for a new trial based on new evidence.
Right, Laura.
Several weeks ago, we filed our informal response dealing with that habeas petition, opposing the habeas petition and saying that the justification for the new trial based on 2 additional pieces of evidence did not meet the legal standard to warrant a new trial. The second track that the Menendez case is on is the clemency track. This is a petition that the Menendez brothers filed directly with Governor Gavin Newsom. He could have acted on this petition either now, he could have acted on any moment since he has been in power since 2019. He can act on it today if he so chooses. He has unilateral constitutional power to commute the Menendez's sentences if he chooses and release them today. There is no hearing he needs to have. There's no deadline, and he can also do nothing. The third track is resentencing, and we are here today to discuss that third track. The resentencing is a law that was passed by the state legislature in California, somewhat unique law to California, that basically gives the judge, under certain circumstances, the power to resentence someone who has been previously sentenced. In this example, potentially, the judge could resentence the Menendez brothers from life without the possibility of parole to life with the possibility of parole. Now, resentencing hearings get started in 2 different ways in this case. One of the ways is that the court has initiated these proceedings itself under Penal Code Section 1172.1A1. The second way it also got started is when the prior district attorney filed a motion under this code section to begin the resentencing proceedings. What the position we are taking today is that we will go forward. We are prepared to go forward with the court's initiated resentencing proceedings and look forward to a resentencing hearing on that motion. However, we are asking the court to withdraw the previous district attorney's motion for resentencing because we believe there are legitimate reasons and the interest of justice justifies that withdrawal. Now, when one deals with resentencing, one of the key hallmarks of resentencing is, do the defendants pose an unreasonable risk of danger to the community? One way to decide if they pose that risk is to understand if they have been rehabilitated. And one way to understand if they've been rehabilitated is, have they accepted and exhibited full insight into the crimes that they have committed and accepted complete responsibility for their criminal actions. Governor Newsom gave us a primer on how this actually works when he dealt with the Sirhan parole recommendation that had been made to him back in 2021. At that point, Sirhan, who was the assassin of Senator Robert F. Kennedy in the Ambassador Hotel back in 1968, had been up for parole hearings 16 times. For the first 15 times, the parole board denied parole. But on this 16th time in 2021, the parole board recommended a grant of parole to Governor Newsom. So he looked at the case and he actually issued a written decision. And in that decision, he analyzed the factors that were both in favor of parole, and there's an analogy to resentencing, and the ones that weren't. The ones that were in favor for parole was that at the time of that parole hearing recommendation, 𝗟𝗏 was 77 years old. He had been in prison for 54 years. He was suffering from a diminished physical capacity. In his childhood background, he had lived through a war-torn area. He was 24 at the time that he committed those crimes. And while in prison for those 54 years, he had engaged in comprehensive involvement in rehabilitative and self-improvement programs. He earned his Associate of Arts degrees and other certificates. He engaged his classification score, which is an analysis by the California Department of Corrections and Rehabilitation as to what type of risk level you're at, was at the lowest. It was a 19. In fact, the California Static Risk Assessment said it was that lowest level. His rule violation reports, that's the number of reports that he had experienced since he had been in prison since 1968, was 2. And the last one was in 1972.
They've done a lot.
He had letters of support from prison officials, and he had letters of support from 3 of the 9 living Kennedy family members. Yet the governor looked at all those positive factors, recommending parole for 𝗟𝗏. Now it's in 2021, 2022. But he said that one factor overcame all those other factors. And that one factor is that 𝗟𝗏 had not demonstrated full insight into his crimes. He had not completely accepted responsibility for his actions based on his multiple stories of what had occurred that night in 1968. So notwithstanding the fact that he did not, he had all these positive aspects, and he had the parole board recommending a grant of parole, in January 12th, 2022, the governor wrote that 𝗟𝗏 poses an unreasonable risk of danger to the community and denied that parole. The reason this can be an instructive case is that there are almost no cases right now on Penal Code Section 1172.1, the resentencing statute. But the focus of it is the same focus as we have in the parole context. Is there an unreasonable...
If you are curious about everything the Menendez brothers did while they were incarcerated, on my playlist, I read the document that listed everything they did, and it's super long, but it's a really good
risk of danger to the community by these particular people. In 𝗟𝗏, he was a murderer of Senator Robert F. Kennedy, and he shot 5 additional people that night. And here we have the Menendez brothers, who are murderers of their parents the night of August 20th, 1989. While 𝗟𝗏 is 77 at the time that Governor Newsom made his decision, right now the Menendezes are either 57-year-old for Lyle Menendez or 54-year-old for Erik Menendez. They've served 35 years in prison.
35.
𝗟𝗏 served 54 years. They don't suffer from the diminished physical capacity that 𝗟𝗏 does. They had also childhood allegations of physical, sexual, and emotional abuse in their childhood. While
I played the old trial too.
Had never been arrested or charged or convicted of any crimes before his offense. Erik Menendez had been arrested for multiple residential burglaries and received diversion. And Lyle Menendez had also been arrested for multiple residential burglaries. When it comes to rehabilitative programs, yes,
I agree, Laura. It's a very different case, right? These guys killed their parents, right? Public figure, right? I agree. It's different circumstances.
Yes, both 𝗟𝗏 engaged over the 54 years in significant programs, as have the Menendezes. When it comes to education that they earned, 𝗟𝗏 earned an Associate of Arts degree. Erik Menendez has earned multiple Associate of Art degrees and is currently enrolled in 𝗟𝗏. And Lyle Menendez earned his Bachelor of Arts degree from 𝗟𝗏.
That must be nice.
As
Go to the UC while incarcerated
at the same level, a 19, which is considered the lowest level you can be at in the prison system. With respect to that California static risk assessment, they're all at the lowest level. Rules violations, you had 2 for 𝗟𝗏, the last one in 1972.
Why is he comparing them?
9
Yeah, I don't
for
like
Erik
that.
Menendez, the last in 2021, and 8 for Lyle Menendez, the last in 2024. They each have
I'm
letters
glad
of
you made it,
support
Jojo.
from prison officials,
Good to see
and the
you.
Menendezes have multiple letters from all living victim family members aside from one who recently passed. And they received those letters in support of their being released. With respect to them, the key issue of exhibiting insight, full insight into their crimes and completely accepting responsibility for their actions, this is where the Menendezes, like 𝗟𝗏, also fall short. As we lay out
Right, Laura.
in
Not
our
even close.
pleading, which is now 87 pages long, we go through a 60-page statement of facts, which is different, by the way, than the 3 pages that the prior motion had laid out as far as the crimes that are involved. And as we show, the essence of the defense that the Menendezes have maintained from the first trial into the second trial to the present day is that they acted in self-defense. They had an actual fear of imminent harm, in essence, that their parents were going to kill them the night of August 20th, 1989. As we show extensively, and just to make this point, that this case is not, or their defense was not about sexual abuse, because I know that issue has come up many times, but about self-defense. I take you to both Erik, Lyle's, and their own attorneys' statements. At trial, Erik testified, and he was asked, "Did you kill your father because he sexually molested you?" Answer, no. "Did you kill your parents because you hated them?" Certainly no, was the answer.
I know, Joe.
"Did you kill your parents because you wanted their money?" Answer, no. "Did you kill your parents as an act of mercy?" Answer, no. "Why, Mr. Menendez, did you kill your mother and your father?" "Because we were afraid." "What is it you were afraid of?" "I was afraid of dying." "Who were you afraid was going to kill you?" "My mom and my dad." Lyle
We
Menendez
see crimes where parents unalive their kids all the time, so I believe that. We're gonna do a Melly After Dark, and you can catch up. Tea time. Correct me if I'm wrong. Did the brothers go on shopping a bit? Yes, they did, Holly. They bought like new cars, all kinds of things, which I would say it does damage.
Only testified as well. That he was asked the question on August 20th, 1989, "Did you or your brother kill your mother and father?"
Right,
Yes.
irony.
"Did you kill them for money?" No. "Did you kill them because you wanted to pay them back for the way they had treated you?" No. "Why did you kill your parents?" "Because we were afraid." That is the essence of their defense at trial. It was not sexual abuse. The jury was never asked to render a verdict on sexual abuse. It was all about self-defense. In fact, Erik Menendez's attorney, Leslie Abramson, said, "We have never said that because you're abused, you're justified in killing your abuser. We didn't argue that and never will." So the question then is, have the Menendezes exhibited
Right, Laura.
insight into the fact that their self-defense defense was fabricated? And as we go through the iterations of their defense that they issued from the time that they were arrested until the time that they went to trial, until the present day,
Right, irony.
what you will see is that the self-defense was the last iteration and version of their defenses. Because remember, the first defense that they came out with was, "We didn't do it. That's not us." If you remember the 911 call, if you remember Erik Menendez screaming and crying when the police came out that night, he says to the police, "We're going to kill them," referring to the people who had just murdered his parents. "We're going to kill them. We're going to torture them." Who would have done this thing? The answer is the Menendezes. But their first iteration was it wasn't them. It was either the mafia or the cartel or the dirty business associates of Jose Menendez. They persisted in this lie, not just the night of August 20th, but kept that lie going for months and months and months. And had Erik not confessed to his therapist, Dr. Oziel, months later, and that confession been taped, and that confession's tape been turned over to the police, they would have maintained it wasn't us. They convinced not just the media, not just the police, but their family and their friends that they were 100% innocent of these crimes, until eventually these tapes came out. They were arrested. Then they changed to the next iterations, because the next iteration of the story was when Lyle Menendez gets his girlfriend, 𝗟𝗻𝗃, to visit him at prison.
Wow.
And says, I want you to testify that my father drugged you and violently raped you, establishing that Jose Menendez was a violent rapist.
Wait, why don't they get another opportunity? But we have Casey Anthony and disgusting Gypsy Rose just walking free, having children, and being on social media like nothing even happened.
𝗟𝗻𝗃 refused to do that.
I don't think those two females should be out.
Was that Lyle Menendez asked 𝗟𝗻𝗃 and said to her, well, Erik Menendez was raped by my father, but I was raped by my mother. That's a story that was then repeated to Erik and Lyle Menendez's uncle, 𝗟𝗲_ᗃ𝗃.
Someone get Justine Casey Anthony, please.
By the father, but Lyle Menendez was molested by the mother. That iteration didn't go forward. The next iteration that ultimately came out at trial, and just before trial, was that both boys were molested by the father. But as you heard a moment ago, that wasn't a defense to the charges of first-degree murder with special circumstances. Because you had to add one more thing that the jury was now going to consider, is not just that they were sexually abused, but they were actually in actual fear of imminent harm, of their lives being taken by their parents the night of August 20th, 1989. So self-defense is the defense that they set forward at the trial. But what we show in our pleading is we go through the timeline to show that the Menendezes have basically engaged in not just the ultimate lie of self-defense, but a whole series of lies around it. And they took actions that were both premeditated and deliberate, not just sort of...
Two things can be true at once, right? Maybe they were going through a lot of PTSD, and maybe they did have a mental episode, right? That's possible. It is. I don't knock that.
Immediate responses to their parents somehow threatening them the night of August 20th. We point out that days before the murders on August 20th, on August 18th, the Menendezes drove 120 miles to San Diego to purchase shotguns and ammunition and used a fake ID and a fake San Diego address to make sure that the guns and the ammunition would not be connected to them. The day before the killings, August 19th, they go to a firing range and they find out that the birdshot ammunition that they had bought isn't good enough to kill someone.
Let's remember this started as children as well. You have to think about if that's true, all the abuse and all the mental anguish and mental stuff that they went through, right? It started like 6, I think they said 6 to 18.
They're told you need buckshot ammunition.
I do believe it was premeditated.
Kill someone, and they buy it that day.
Not today, irony.
Hours before these killings, at roughly 10:20 p.m. on the night of August 20th, Lyle Menendez contacts one of his friends, Perry Berman, to set up the alibi. And the alibi was that they were going to go to Batman movie at the 8 o'clock showing. And they would be at that movie when the killings would have occurred, and then meet Perry Berman at the Taste of LA event after.
Okay, Laura says, I don't think anyone's questioning that they didn't lie 1 million times. To me, that even proves more they weren't freaking masterminds. They were terrified kids. I agree with that as well. I am doing her, Jules. I'm working on it. It's a lot. I know loved ones that wanted their abusers unalived. Very true. I actually know someone who experienced SA as a child, and she was totally fine. And she didn't start having like these kinds of thoughts on unaliving people until she was like in her 30s. It was like,
afterwards.
it was wild.
They set this up before.
So I believe that for sure.
Now, during these killings, as we've explained before, these
Like
weren't
the
just a
trauma started affecting
situation
her. She was
where all of a
scared.
sudden the parents threatened their lives. They reached for something and shot them dead. No, these killings, the actual shots, were designed to make it look like a mafia gangland hit. They shot Jose Menendez through the back of his head. They shot Kitty Menendez not only once, which then caused her to go down to the ground bleeding, but when they ran out of ammunition, they went back to the car.
That's usually what happens.
Shotgun.
They suppress the
Menendez
thoughts and
took
feelings.
the shotgun, put it up to Kitty Menendez's face,
Right.
and pulled the trigger. Again, to make it look like a gangland shooting, but that was not enough. They then, while they were dead, shot them in the kneecaps to make it to complete the picture of what a gangland shooting would be. But and at that point, they also had the presence of mind to pick up all the shotgun shells that were lying in the den because they were worried their fingerprints might be in them.
He's not a fan of
They
the
then
Menendez
called Perry
brothers.
Berman to establish the alibi and went to the movie theater to buy the tickets, only to find out they couldn't buy the 8 o'clock showing because the next showing had already occurred. And Perry Berman had already moved on to a different event, so they couldn't meet up with him. So they took all those shotgun shells, they took the bloody clothing, they go to a gas station dumpster, and they dump it in the dumpster. But now they got the shotguns, what to do with them? They had the presence of mind to drive up to Mulholland Drive and throw the shotguns off the hill on Mulholland
Repressed
Drive.
memories are real.
They then went back to the house. When they get back to the house, that's when they read the 911 call that someone killed our parents. And then when the police arrived, that's when they said, as I said before, when Erik and Lyle are running out screaming and crying, and Erik says, I'm going to kill them, I'm going to torture them. Who would do this?
Natasha.
Knowing, of course, that it was him and Lyle who had done that exact crime a little more than about an hour and a half beforehand. So you had a situation then.
Yeah, sorry about that.
They engage in this deception, the mafia hoax, the lies to their friends, their
guy's
family,
like pissing me off.
The police. And what's interesting as well is the actions they take immediately afterwards. If these were kids that had just lost their parents, you would think the last thing in their mind would be to check on where the will is. But sure enough, within 48 hours, they go ahead and obtain the computer that they believed a new will had been written on, disinheriting them, bring in a computer expert to delete and then double delete all the files dealing with.
I agree, Laura. You guys. Someone's like, boy, he has a lot to say, Jojo. And then this guy's acting like he's a freaking academy. I agree. Hey, 𝗟𝗶𝗸𝗲, good to see you. Yeah, he needs to take a chill. Like, chill out. Chill out. I'm shook.
Erik, Lyle, or Will that are on the computer. Go ahead and remove the safe from the family home into a neighbor's home to look at the safe only to determine there was no will in that. And then even go to the bank safe deposit box to go ahead and see if Jose Menendez had put the new will there, disinheriting his sons.
Maybe I should deep dive this man on the screen. Eh?
He told them he was going to do.
So
the story again keeps going on, and today Erik and Lyle Menendez, at least from the beginning, fully expected for them never to go to prison because they had successfully convinced everyone that they didn't do it until they spoke to Dr. Oziel. And Erik, feeling the pangs of guilt, feeling even suicidal, talked to Dr. Oziel and basically told Dr. Oziel that they had done it. When asked about why they killed their father, they didn't mention self-defense. Why they killed their mother that night, they didn't mention self-defense. What they said about the father, what Erik said, is that he was a controlling, dominating force, and that is the reason that he was killed. When he was asked about the mother, He said the mother would be a witness to the crime, so she had to die. That the mother was so miserable because the father had had an affair that we needed.
The mother sounds like a freaking Jen Soto. I can't even say her name. I have a live coming up on that clown, but Jen Soto participated, in my opinion. This mother could have too. Was she scared of her husband? Possibly.
To put her out of her misery, that the mother could not live without the father, and if we're going to kill the father, we had to kill the mother. What doesn't happen in any
stinky,
of the
rotten
conversations
potato
with
that
Dr.
smells like
𝗍,
rotten
and
fish.
remember, he is being brought on by the attorneys to eventually go ahead and prepare a defense to the murder charge. So what they never tell Dr. 𝗍 in all the tape confessions is that they were in any fear of their life, that their parents were going to kill them that night or any night, and that they experienced sexual abuse by the father.
Homie, are you good?
Then goes on because once they get into jail,
I know you guys
additional lies come up. I've spoken before about the lies that Lyle tried to tell with 𝗵𝗵𝗃𝗃 about her being violently raped by Jose Menendez. They also enlist another of Lyle's girlfriends, Tracy.
Okay, number 7.
Where Lyle literally writes her a script, a letter that is found later that lays out a story of the mother trying to poison the Menendez brothers and the entire family. Tracy Baker actually testifies to this false story in the first trial, though not in the second. And not only that, but Erik and Lyle Menendez
I can't stand her either,
to this fake mom's going to poison us story. What we also find out is that Lyle enlists one of Erik's friends, a guy named Brian 𝗟𝗏𝗻𝗄, to go ahead and corroborate the self-defense story. How is he going to do it? Because the letter that Lyle writes to Brian 𝗟𝗏𝗻𝗄, which is actually found by the police, gives detailed instructions down to the actual word that Brian's supposed to say that the day before these killings, the Menendez brothers came to him to get his handgun in order to establish that they had this fear of their parents, even at 24 hours before, and tried to get a handgun. That is actually disproven. And when it's disproven,
I don't like this guy.
Again, Brian 𝗟𝗏𝗻𝗄 says, look, I didn't have that conversation with the Menendez brothers, and I didn't even have a
Who thinks he stood in front of the mirror and practiced this? Because I'm starting to think he did.
Handgun to give them, even if they said that I did. So you had these situations. The Brian 𝗟𝗏𝗻𝗄 attempted suborning perjury. The 𝗍𝗵𝗃𝗃 attempted suborning a perjury, and the Tracy Baker actual suborning a perjury that the Menendez brothers engaged in to establish this self-defense. But it failed. And the reason we know it failed is that a jury heard all this evidence. And the jury, the second jury, the first jury hung, but the second jury that heard all this evidence rejected the self-defense and found them guilty of first-degree murder for both parents with special circumstances. And what's also important to note is that this conviction has been run by 5 different courts over the last 30 years. It went to the California Court of Appeals. It went to the California Supreme Court twice. It then went to the U.S. District Court. It then went to the U.S. Ninth Circuit Court of Appeals. The Menendezes have brought up every single argument that they bring up now about the faulty jury instructions, the exclusion of certain sexual abuse evidence at the trial, about certain other court rulings, and it's been rejected and rejected and rejected over and over and over again. So, in looking at then whether or not the Menendezes have exhibited the full insight and complete responsibility for their crimes, they have not. Because, and we outline this in 20 different lies that they have told, which is an attachment to our submission. They have told 20 different lies. They've actually admitted 4 of them, but 16 lies remain unacknowledged. They persist in these lies to this very day. So like with 𝗟𝗏 not being able to exhibit full insight into his actions, so too the Menendez brothers failed to exhibit full insight into their actions. Let me give you 4 examples where they've actually admitted to the lie. Erik and Lyle lied on the 911 call about just discovering their parents' bodies. Again, when they were found out and the tapes came in, they admitted to that lie, and I mean the lie of the 911 call. The second lie that they've admitted to is that they lied to the police, family, and friends and the media about their involvement in the murders. Again, when their confession came out on tape, they had to admit to that in the first and the second trial. They admitted that they lied to the police, family, and friends, suggesting the mafia was involved
He's
in
a
the
district
murders.
attorney, Los
And
Angeles.
Erik admitted that he
attorney.
lied when he told his expert psychiatrist, Dr. 𝗟𝗃𝗃, that his parents would kill him because his father's homosexual lover warned him that he was in danger 2 days before the murders. This is something that Erik Menendez told Dr. 𝗟𝗃𝗃, and then months and months later finally recanted and told Dr. 𝗟𝗃𝗃 that that was a lie. But there are 16 lies that remain to this day that have been affirmed as recently as last year, where they affirmed the self-defense and they've never admitted to the suborning of perjury of others or the attempted suborning perjury. These lies include when Erik and Lyle claimed that their parents were going to kill them, that they had to act in self-defense by murdering them first. That the Brian S. Lamina letter, that they basically tried to suborn perjury from Brian S. Lamina, telling him to testify that they borrowed one of his handguns.
He doesn't think that they should get a new resentencing.
Another lie that they told to support their self-defense story is that on that Friday, when they go down to San Diego, they said they actually didn't start in San Diego. They said they started at the Big 5 sporting goods store in Santa Monica to try and buy handguns. That unfortunately, there was a 14-day waiting period, they said, so they couldn't buy the handguns at that Big 5 sporting goods store in Santa Monica. They both testified to this. Turns out, as the evidence came in at trial, the Big 5 sporting goods store in Santa Monica hadn't sold handguns for 3 years at that point. So it was impossible for them to have actually gone and tried to purchase a handgun instead of a shotgun that particular day. They've never admitted.
If you missed the first half of the live, we read the first half of the document, the petition, and we're going to finish it tomorrow.
That they provided that fake ID and fictitious address
Check
to
out
buy
the
those
playlist.
shotguns in San Diego in order to conceal their connections to the shotguns and the ammunition. They just said that they used a fake ID because they had driven all the way down to San Diego and forgot their California driver's licenses. They testified that the day before the murders, they had stayed away from the home all day that Saturday, even though a witness came forward, who was the pool repairman, who said they were playing tennis that day at the house and disrespecting the parents who were in front of them. Again, another lie which they have never acknowledged. They lied when they said they didn't plan that alibi before the murders. They lied when they said they did not ask Perry Berman to come back to their house in order to be a witness on the discovery of the mutilated bodies. They lied when they said that they did not stage the murders to look like a mafia gangland hit. They lied when Lyle said they tried to suborn that perjury from 𝗟𝗵𝗃𝗃 about his father drugging and violently raping her. They've never admitted that they lied when they testified that their mother was so dangerous and unpredictable that she tried to poison the whole family. And they've never admitted the suborning of perjury from Tracy Baker when they actually got one of Lyle's girlfriends to testify to the fake mother's poisoning the family story at trial. They further lied when they testified that they thought their parents were going to kill them during their Saturday afternoon fishing trip. They lied when they testified that when they burst into the den with their shotguns, that it was too dark to see and their parents were standing up or moving towards them. Expert testimony showed that at all times, the parents were seated on the couch when they were shot, or mom was on the ground bleeding to death when Lyle
Yeah, this
came
is someone
back.
who's opposed to them getting a new opportunity for resentencing. So I agree, Holly. Just because this man is saying his lies does not make it. So these damn people put a spin on everything. Right. I agree.
Shot her in the face. They lied when they said that they testified that the reason they rushed in on their parents was because of self-defense, and they thought that their parents were going to shoot them first that evening. And they lied when they testified that Dr. Oziel blackmailed them into confessing on tape to murdering their parents. We lay out this series of 16 of the 20 lies that they have never acknowledged.
This guy
never showed insight into, never completely accepted responsibility for. By the way, what I just described to you was mentioned in a paragraph in the original motion that was filed by the district attorney's office. There was no discussion of exhibiting insight into one's actions or completely accepting responsibility for it in the original motion. So we are basically, in some ways, offering a path to the Menendez brothers. And here's what the pathway looks like. If the Menendez brothers at some point,
that's true, domestic
sincerely and fully accept complete responsibility for all their criminal actions, acknowledge that the self-defense defense was phony, and their parents weren't going to kill them the night of August 20th when they murdered them in cold blood, acknowledge that they suborned or attempted to suborn perjury in all the various ways I have outlaid. If they go ahead and finally come clean,
we'll meet up, Natasha,
with the public, with the DA's office, with their own family members, and acknowledge all these lies, and then can be said to have fully and completely accepted responsibility for their actions. In the future, the court can weigh these new insights into making a determination as to whether they now qualify for rehabilitation and resentencing. And the people
I agree,
will do the same. The district attorney's office, if it is presented with these new insights, unequivocal, sincere acknowledgments of all the lies they have told for the past over 30 years, we too,
all the lies,
attorney's office,
what a jerk,
will reconsider whether or not we would want to go forward with a resentencing motion.
I'm not okay with the knocking, the essay abuse, and all of that. I think that's gross.
But for now, while the Menendez brothers persist in telling these lies for the last over 30 years about their self-defense defense, and persist in insisting that they did not suborn any perjury or attempt to suborn perjury, then they do not meet the standards for resentencing. They do not meet the standards for rehabilitation. They have not exhibited the full insights and accepted complete responsibility for their actions. And as a result, just like in the Sirhan case, they pose an unreasonable risk of danger to the community, and the resentencing should not, therefore, be granted. I'm going to stop now. I'll take any questions that anyone has. After I'm done with these questions, Maria Ramirez will address the Spanish-speaking media and provide information at that point.
The hearings on March 20th and 21st, there's word that they have been postponed. Is that the case?
So those hearings, whether they occur on March 20th or 21st or at some point later, first it's up to the court on what the court ultimately wants to do. The court is receiving our response today. We anticipate the court may keep the March 20th and 21st dates to deal with our response. Again, part of our response is to go forward with the court's initiated motion for resentencing, and part of our response is a request to withdraw the DA's motion in this regard. The court might have the hearing then on that issue, and then if in fact it decides to go forward with the full resentencing, set a hearing in the future. I know that the governor has now ordered the parole board to do the risk assessment. That risk assessment can take up to 90 days. We don't know.
They served 30 years. I mean, they're taking responsibility, right? I mean,
when it will actually be completed. The court may or may not want to have that risk assessment done before it has the final resentencing hearing.
Yeah, can you just clarify? So obviously you've laid out this case. This reply motion will be in the file no matter what, but you cannot pull back Gascon's motion. You're asking the court to pull that away. If they decline in this hearing, the court will then have to weigh both motions equally. How does this?
Gascon even wanted them to have
Effectively,
another
yes.
opportunity.
So what will happen is, again, you have, in some ways, double motions going forward. And in looking at the different motions, we have now analyzed the original motion filed by the district attorney's office and saw that in no way, shape, or form did they deal with what we believe to be one of the key issues, this exhibition of full.
Yeah, I'm not a fan of the court.
Complete responsibility for one.
They're really not a fan of me either.
So we are pulling back or asking the court to withdraw that motion, while we're also indicating to the court that we're prepared to go forward on the court's own motion for resentencing.
Considering all the facts that you brought up, do you think there's any chance the Menendez brothers are going to get out of jail in the next few years?
Again, we have laid out a pathway for the Menendez brothers to potentially get out of jail. It requires them to finally, after 30 plus years, fully acknowledge and completely accept responsibility for the entire.
Okay. The male brain isn't even fully developed until like 25. I think they should be allowed, or new resentencing or new trial or whatever. Right? Like I said, Gypsy Rose is out there.
Entire breadth of the crimes and all the lies that they have told, including their defense at trial of self-defense. If they go ahead and do that, and they do it unequivocally, and they do it sincerely, ultimately the judge is the final arbiter of that, of the sincerity and whether or not this is just being done to please someone, or whether or not the Menendezes have fully come to grip with the lies that they have told. Again, they had no problem at trial coming to grips with the fact that they had lied for over 6 months to the police, the media, their family, and their friends.
Kind of sounds like it,
about the fact that they never did it, were not involved at all, and it was the mafia that had actually done the hit on their parents. So they have a history of acknowledging some lies. I'm hoping that they continue with this evolution of themselves, their improvement of themselves, to finally come to grips.
Oh my God, I need an aspirin after this guy.
Of their crimes and their lies. And at that point, the court may very well entertain the idea that they have met all the criteria to not only be rehabilitated, not only no longer pose a danger to society, but to be resentenced.
But you don't think they're getting out of jail until they do that?
Our position is that they shouldn't get out of jail. Now, ultimately, that is a position. We bring that position to the court. The court can agree with it, the court can disagree with it, or modify it in some respect. I'm sure that the Menendez's lawyers will be arguing that the court should go forward now with the resentencing. I've spoken to the Menendez family members. And by the way, I spoke to the Menendez family members who support the Menendez brothers before I spoke to Milton Anderson, who recently passed. I spoke to him after I spoke to the Menendez family members, and they certainly would like him out, or them out, tomorrow. And they'll be encouraging the judge to do the resentencing now. But as we have looked through the facts and the law, and that's what's governing our opinion. It's not emotion, it's the facts and the law. They have failed to meet these requirements to show that they are no longer an unreasonable risk of danger to the community. And that is why our position is that resentencing, if it occurs, they shouldn't actually be resentenced.
Sir, just to clarify, you outlined all these.
People are like coming at him.
We have not actually spoken directly to the family today. We filed this at the earliest possible time we could at 8:30. Having this press conference at 10. But when I spoke to the family before, it was an over 3-hour meeting with the family members, the over 20 family members that support the Menendezes being released. And we talked about their rehabilitation.
He's very passionate about this, huh?
We talked about their beliefs of what happened at the time of the crime. We had a very wide-ranging conversation, and I sat there and I listened to it all.
Domestic.
But it does not eliminate the fact that in order to show a full and complete acceptance of responsibility and show full insights into one's criminal actions, that as we have laid out in detail, the self-defense defense was a fabrication. They need to admit to that. They need to admit that they suborn or attempted to suborn.
Yeah, they want them to
perjury.
admit it.
And at that point, we might be in a position, if they do it sincerely and unequivocally,
Holly, there you
to be
go.
in a position to then go back to the court and recommend resentencing.
On the note of the
Right
handful
here.
of weeks, what if they do that in the next couple of weeks before the resentencing hearing? They acknowledge everything, and would you find that to be sincere? Would that
Yeah,
change your
given that
opinion?
you've talked about all the lies they've said, how would anything that they would tell you, how would you deem that to be sincere after you've gone through this whole litany of lies that you claim they've made?
I will address that in the same way that people ultimately were able to believe the Menendezes.
I feel like
when
this
they
man would
admitted
definitely send me to
the
jail.
first several lies, the first 4 lies. Because remember, at that point, you had a situation where the Menendez brothers said, we didn't do it.
Good point.
The mafia did it. But they took the stand repeatedly at trial and said under oath that no, we lied when we said we didn't do it. We lied when we said the mafia is the one who gunned down our parents. And they were able to, again, express under oath that belief, and they did it over and over and over again. So if the Menendezes go ahead and want to, at any point, whether it's today, whether it's weeks from now, months from now, or years from now, finally and unequivocally express that they acknowledge the lies that they have told and persisted in for over 30 years. And we will certainly evaluate the quality of that sincerity and decide whether or not it's real or fake, whether or not it's just designed to get out of jail, or whether or not they truly believe and acknowledge the full breadth of the crimes and lies they have told in deciding what to do at that point. And as importantly, the court will have to make that decision. And that decision is the court and the courts alone to make.
Okay, so if the court's going to make that decision, it's their decision to make. They should get another resentencing trial, right?
The family filed a Marcy's Law complaint. I'm sure you've seen this.
Sucks for
wildly
them.
different characterization of the meeting than you've offered in the past. They are actually claiming you were hostile towards them, that there was they are looking at
Oh, you were hostile toward them.
I don't know if you have any
Sure.
different characterization of that meeting. Do you dispute that? The description that they
Look
made?
at him.
So it was a 3-hour meeting.
I think he gets Botox.
The district attorney is not obligated to meet with any of the family members. Not even obligated to necessarily, certainly not obligated to meet in person. I could have taken written communications from any of the family members and actually did receive some written communications. But I sat there for over 3 hours. I didn't tell.
If they were this wealthy, couldn't they have just hired someone to do it? I mean, we're deep diving 𝗟𝗶𝗸𝗲, right? And his ex-wife paid someone to take him out. I mean, they could have done that. They were very wealthy.
Any of the Menendez family members what to say or what I wanted them to say. I said, whatever you want to say to me, please say it. And I sat there and listened to everyone who wanted to speak to me until they were done speaking.
Thank you,
So if they characterize that meeting in whatever way they're going to characterize it, so be it. I understand that the Menendez family members want, the ones that are supporting this, want the Menendezes out today. They could go to the governor. They wanted to actually achieve that. Literally go to the governor Newsom today, and he could commute their sentences and release them today. I, on the other hand, am bound by the facts and the law as it pertains to an analysis of whether or not resentencing is appropriate. And that is what I've done. You know, again, the jury heard this self-defense defense way back when, and the jury rejected it. We're just basically, in many ways, following the jury's verdict from way back then, while the Menendezes have for over 30 years not only rejected the jury's verdict, but persisted in the lie of self-defense and the related lies I've talked about.
Why still go through with this while it's in the governor's hands? Some could say it makes no sense.
Why go through the resentencing? That's actually up to the court. The court can decide to continue a hearing.
Up to the court, sir, not you.
The court can have and keep the hearing on March 20th and 21st. District attorney is not going to tell the court what to do in this respect. Yes, over here.
What about the issue of the age they were when they committed these crimes and how laws have changed with regard to life without the
Oh, this is a good question.
A good point. 𝗟𝗏 was 24 years old.
We don't-
And the law
we're not here to
says
hear about
that
𝗟𝗏.
youthful offenders are under the age of 26. If you actually look at the governor's decision dealing with 𝗟𝗏, he mentioned that he has to give special consideration to the age of a particular person, particularly if they're under 26, that the law requires. And so too, for resentencing, should the court give such consideration to the age of the offender. 𝗟𝗏 was 24, Lyle Menendez was 21, Erik Menendez was 18
I hear that name again
when
one
they
more time.
committed their murders. So yes, we need to give that consideration to the age of the offender. And I use the example of 𝗟𝗏, where that consideration was given,
That's it.
but yet the failure to exhibit full insight into one's actions and completely accept responsibility for the breadth of one's crimes overcame the parole factors that the governor considered.
Going back to what the family had claimed in their letter to the U.S. Attorney's Office, beyond how they framed the meeting, they say in an ongoing way you are biased against the Menendez brothers. How do you respond to those claims?
I am not. As I've said, not only am I not biased, but I will file the facts and the law wherever they take us. And in fact, so much so that I've explained in quite long detail exactly where the lack of insight into their criminal actions occurs. I've outlined 16 different lies, 20 lies total, four of which they've acknowledged, 16 of which they have not. So I've outlined a pathway in the district attorney's position on how the Menendezes could exhibit these new insights. Now, whether they're sincere, whether they're unequivocal, that's between the Menendezes and mostly the court as to whether or not the court actually believes them. But if that were to occur, then I've said the district attorney's office, if it believed that these new insights were sincere and unequivocal, then we would reconsider whether or not we would go forward on a resentencing motion.
You referenced your new filing is 60 pages, and the filing from the previous DA's office was just 3 pages.
What I meant to reference, if I wasn't clear, is our statement of facts dealing with the crime was 60 pages. The statement of facts dealing with the crime in the original motion was 3.
Do you think that was incomplete?
I'm
Do
sorry?
you think that was incomplete? Do you think they did a poor job or poor framing?
I think it was incomplete because they never undertook the key analysis of whether or not the Menendez brothers have exhibited this full insight into the breadth of their criminal actions, or completely accepted responsibility for all of them. As a result, we spent, and also the original pleading focused mostly on the probation report, statements made in the probation report. We went to the trial. If you actually look at our 60 pages, there are references to trial transcripts. There are references to court appellate opinions that analyze the facts. We didn't rely on a probation report where a probation officer is summarizing testimony, where that testimony is not under penalty of perjury and not subject to cross-examination. We went back to the source materials. Now, what was involved in that? It was a review of most of 50,000 pages of trial transcripts from 2 months long trial, thousands of pages of prison records, hundreds of hours of videotaped testimony. We also spoke to prior prosecutors, defense counsel, the Menendez family members, as I mentioned, and law enforcement. So we did our last several months, a full debrief and download on the Menendez case to arrive at the position that we've arrived at today. I'll take one more question right here.
Who would they have to tell that they accept or take responsibility for those lies or actions? Who would they have to express it to?
They can do it in any form. Ultimately,
yeah, they really want them to admit to it
because the court will be the arbiter and the judge of whether or not the Menendez brothers have finally exhibited full insight into their crimes and completely accepted responsibility for them. So, however, the Menendez brothers want to convey that sincerity and that unequivocal admission that they have lied to everyone for the past 30 years on their key defense of self-defense, suborning perjury, and attempting to suborn perjury, I will leave to the Menendez brothers and their counsel.
It has to be during a hearing.
It can be in any form. They can do it with declarations. They could do it with videotape testimony.
Wow.
They could do it at the actual hearing itself. I'm not going to in any way suggest how they do it. They have a very qualified counsel who can advise them how to do it. It's up to them, though, on whether or not they want to do it. All right, I'm going to stop right now. I will turn it over to Maria Ramirez for any one-on-one interviews. They'll be in the green room. And thank you very, very much for being here today.
Well, there we have it. So you guys make sure, I can't stand streaming. Make sure you go back and listen to the first half of the petition. I think it's pretty good. I'm going to finish the other half tomorrow. I was honestly shocked to hear this because any other coverage I had seen about this prior was in defense of the brothers. Yeah, I think they should get another resentencing, in my opinion. And I'm curious to see what the rest of that document entails. So I appreciate you guys for being here. I had been wanting to do a Menendez brothers update, but we have a lot going on this week. So I hope you guys will be, I know, 𝗟EIE After Dark too. There's a lot to update you guys on. Lots of true crime. We are deep diving 𝗟𝗵𝗃𝗲. We are deep diving. We're going to start deep diving a new case. I'm going to start doing a collab with someone. We're going to continue to cover John Paul Miller. We're deep diving a bunch of people. So lots of cases. Where was I? Questions. We can talk about that on an After Dark. But I appreciate you guys for being here and hanging out and listening to the document. I hope you guys come back tomorrow so we can finish part 2. It's like a 90-page document. I think we got through like 45 pages today. So I needed to catch up on this. I'm hooked on knowing more of this case. Yes. Come back tomorrow, Holly, to finish the document. And like I said, I have a playlist. We started covering the old trial day by day. I should finish that. And then I did read the document about how much the Menendez brothers rehabilitated themselves while they were incarcerated over 30 years. And that was a really good document too. So make sure you guys hit the playlist, hit the like button. I appreciate you guys for being here. I'm curious to see what happens with the Menendez brothers. There's a hearing set for March 20th and March 21st. So I'm sure we're going to get lots of more information there. And I will cover it. Definitely cover it. And thanks, Domestic. Yes, I have the best mods in the world. Yeah, we vibey here. So I will see you guys tomorrow for another True Crime Live. 𝗟EIE After Dark tonight, �possible. If not, maybe tomorrow. But I appreciate you guys for being here. Make sure you hit the like button, do all the YouTube thingies. Shout out to all my mods for being here and being supportive and amazing. We in there like so many. And the 𝗟EIE, yeah, you're on the team. Yeah. Thank you, Pantera. Yeah, have a good night. And I will see you guys on the next True Crime Live or 𝗟EIE After Dark. Bye. And thank you for being here again, by the way. I appreciate you guys. So I'll see you guys on the next one.
Shining in the Cali sun, really on the case, so no point in trying to run. The sun's can ask for 𝗵𝗃, but you getting none. It's crime o'clock with 𝗟EIE, let's have some fucking fun. Some try to hide away, so all they do is work. But nobody can hide once she gets a hold of that paperwork. So don't you dare come in here acting like a jerk. Dance might make her dance, but new court docs will make her wanna twerk. Dark hair shining in the Cali sun, 𝗟EIE on the case, so no point in trying to run. You Sims can ask for 𝗵𝗃, but you getting none. It's crime o'clock with 𝗟EIE, let's have some fucking fun. So if you're feeling for true crime, like it's a drug, 𝗟𝗶𝗸𝗃𝗲 is your motherfucking plug. Going so hard on criminals, they'll call their mama for a hug. She's finding out all the stuff they try to sweep under the rug. Dark hair shining in the Cali sun. Nelly on the case, so no point in trying to run. You sense can ask for feet pics, but you getting none. It's 𝗟𝗶𝗸𝗃,